seated. Welcome back. I trust you had a good lunch. That's maybe see some sunshine. Before our lunch break, we were still in the defense case in chief, still in the direct examination. Dr. Calloway, Mr. Casanova, you have additional questions for your witness?
Yes, Judge. Dr. Calloway, before the lunch break, we talked about what you had identified as the stressors or the triggers for the diagnosis of psychotic disorder. And I believe those included Mr. Dorsey's mother's illness, end of his football career, decreased academic performance and withdrawal from college, breakup of 7-year relationship with Bianca Davis, and loss of employment due to pandemic.
Yes, that's correct.
Can you explain what role the impact of these stressors or triggers may have had on Mr. Dorsey due to the fact that he was also suffering from a mild neurocognitive disorder?
The mild neurocognitive disorder puts someone at a disadvantage. They already have deficits in their ability to sort of think through things and reason. So they're starting off in a worse position than your average individual. And then you have that these stressful events occurred. Each one alone may not have resulted in this, but that cumulative effect of all those stressors at the same time with someone who's already has deficits tends to cause problems.
I mean, these types of things may cause anybody to feel depressed or unhappy, but given Mr. Dorsey that he's coming to experience these based upon his neurocognitive deficits, they would have a much more impactful, a greater impact on him.
It'd have a greater impact, and then you also have, it's more difficult for him to cope with those things as well, and to figure out how to react to them, how to deal with them, what to do about them. We already talked about, as part of your diagnosis, you have a rule out of schizophrenia, which basically means that at this point, that's still a possibility. Still have to see how things may play out as time goes on. Is that correct? That is correct.
And when we're talking about brief psychotic disorder and schizophrenia, they're both identifying psychotic behavior at the time of the incident as the key symptom. Is that correct?
Yes, the commonalities between brief psychotic disorder and schizophrenia are the psychotic symptoms. So again, that could include hallucinations, delusions. For Mr. Dorsey specifically, that was the paranoid thinking, the delusions at the time. So that's where the commonality is. Both diagnoses, someone experiences psychosis, and that psychosis is causing significant distress and significant impairment. Where things differ is with schizophrenia, the expectation is that someone is going to experience symptoms throughout their life. They may wax and wane, but it is a chronic condition. With brief psychotic disorder, the expectation is that within a month or less, those symptoms subside.
And I want to now talk to you about ability to appreciate wrongfulness, specifically the key time frame at the time of the event. Could you recap for the jurors, based upon all the collateral sources as well as the clinical interview of Mr. Dorsey, what facts and behaviors you identified in supporting your opinion that at the time of the incident, Mr. Dorsey did not appreciate the wrongfulness of his action?
First and foremost, a mental disease or defect has to be present. And for Mr. Dorsey, it was my opinion that a mental disease was present. He was experiencing psychotic symptoms, paranoia, delusions. Those were observed by family, friends, Those were documented in the records after this incident, and then also could be observed during listening to the 911 calls, and then also when seeing him do the interview with police. So that has to be there to begin with. So it was clear to me from reviewing all the records that he had a brief psychotic disorder and was experiencing psychosis at that time. The next step is determining was he able to appreciate the wrongfulness. There's a lot that goes into that analysis. Part of it is knowing what are indicators that someone did appreciate that it was wrong. Things that are commonly seen and are documented in research are, did someone hide evidence? Did they discard evidence? Did they try and conceal what was happening? Did they try and, lie or mislead people about what was going on? Those are often indicators that someone knew it was wrong. Other times you can have someone in the moment apologizing. All of those could be potential indicators that someone knew it was wrong. Typically, it is not just one thing. It is a combination of factors. So it's looking at all the behaviors, all the statements that the defendant makes and that other individuals make. In this situation specifically, I looked at it in the context of Mr. Dorsey's life and then in the context of this specific situation. So the backdrop is you have an individual who hasn't been in trouble before, hasn't engaged in antisocial behaviors, hasn't been known to be a violent person. So that's sort of the backdrop for him. And then I looked at this specific situation and what occurred. So he is experiencing paranoia and delusions and thinks these things are happening, but they're not in reality. And he did not make any attempt to hide or conceal any information or any things that were going on. Instead, he did the opposite. He asked Ms. Brown to call 911. He was calling family and telling them what was happening. So it's not as if he was being violent towards Ms. Brown and trying to hide or conceal those behaviors. Instead, he is telling her to call police. He is talking with the dispatch. So there's no attempt on his part to hide or conceal his actions. Some of the other indicators were that his behaviors were directly related to those delusions. So he thinks that she is setting him up and someone is going to kill him. And his behavior in that moment is congruent with that belief. He doesn't act in a different way. He thinks that when he hears that knock on the door, someone is coming to rob him and kill him, and Miss Brown has set him up. And he responds in that way because of those paranoid delusions. When he's you can hear on the 911 call, you can hear him continue to state that he thinks that he's going to be killed. And so all those things combined, in my opinion, show that he, in that moment, was not able to appreciate the wrongfulness. He's experiencing delusions and paranoia. He is acting on those. And in that moment, when he hears the knock, he, seconds earlier, had thought he heard Miss Brown say, "Come and get this N-word." And here's the knock, and he thinks in that moment his life is threatened and that they're coming to kill him, and he responds accordingly. And so in that moment, those are most important. And there are also indications afterwards that he continues to have those same beliefs that someone was coming to kill him.
And would that include the statements that he made to Ms. Brown after he shot her, as well as taking phone from her?
Excuse me. Sorry about that. Yes, so you not only have, sorry, is it okay? Just take a second.
No, why don't you
Clear
take
it.
another drink?
Thank you. So you have him reacting in the moment when he hears someone knock on the door. And then you also have that when Miss Brown leaves the apartment and he then shoots her, follows, goes out there, and he says to her, "You're slick," and takes her phone. Those are also indications, thank you so much, appreciate it. Those are also indications that he continued to have paranoid delusions, that she was also part of what was going on, and that she was still a threat. During my interview with him, he had indicated that he thought she was going out there to get someone. So again, a continuation of that. And then in her deposition, she had also said that he thought she was still part of that conspiracy to kill him. So those things combined show that in that moment, because of his paranoid delusions, he is acting in a particular way, and he thinks that is what he needs to do in the moment to save his life.
I want to talk to you a little bit about the issue of malingering. And the jury's already been kind of told what malingering is and how important it is to identify in a clinical setting whether somebody is malingering. And is that, would determining whether or not there is malingering going on be a critical piece of any clinical evaluation and any forensic evaluation?
In clinical evaluations, it is less common because normally someone's coming in for treatment or an evaluation. People that do clinical work still look for that, but not nearly as frequently. But what you have in forensic evaluation is there is a lot at stake. There is research that's been done that shows there are people who feign or exaggerate either cognitive deficits or any kind of psychiatric symptom, potentially psychosis, in order for some secondary gain, maybe avoid prosecution, get to a hospital instead of somewhere else. There's research that supports that there are individuals involved in the criminal justice system that malinger or feign psychosis. So it is critical when doing these evaluations that is something that's taken into account.
And with regard to Mr. Dorsey, were there observations that you made of him when you met with him as early as July of 2020 and then subsequently that indicated to you he was not malingering?
There were multiple indicators, not just from my interviews, but also from a review of all the other documents. When people malinger, what you commonly see is that they sort of give a dramatic presentation of symptoms. For example, I've evaluated individuals that will do this, and when they walk in the room, look around, acting as if they're hearing voices, when that's not how people usually respond when they're hearing voices. So usually people draw attention to their symptoms, they act them out in sort of a dramatic way, they continually want to talk about them, they describe odd combinations. So what I mean by that is, we know what psychosis looks like based on research, based on observation, based on experience. But individuals that are trying to feign illness don't know what it looks like. And so they will often act in a way that is not consistent with how people who actually have psychosis act. So part of looking out to see if someone is malingering is observation. Is what they're reporting consistent with what people with mental illness describe? Is what they're reporting consistent with what the research says about mental illness? And then the other things that I'm looking for are consistency. Are people describing things the same way from one interview to the next? Or does their description of what their symptoms or what they're experiencing change over time? And then the other thing that I do is a comparison. What they discussed with me, is that what other people have observed and reported? Is that what the individual has told other people? It is very difficult to continually feign psychosis or any other type of mental illness or cognitive deficit. And in this case specifically, I saw the opposite, particularly in those first two interviews. Multiple times Mr. Dorsey said he essentially was guarded and didn't want to talk about some of these things. He said, I'm not crazy, I don't want to be viewed as crazy. And I did not see any of the characteristics of someone who was feigning. Instead, I saw someone who was having a hard time acknowledging what they had experienced, did not want to be seen as having psychosis at that time, and certainly did not want to be seen as someone with a mental illness or a mental health difficulty.
And did you actually, at one point, I think in March of 2022, administer some standardized tests designed to detect malingering in order to confirm those opinions?
Yes, I did. There's tests that we use as psychologists that evaluate that exact thing. Some of those evaluate if someone's feigning psychosis or any other type of mental health symptoms. Some of the other measures evaluate is someone putting forth effort or are they feigning memory impairment. I administered, it's called the Miller Forensic Assessment of Symptoms. It is MFAST for short. It essentially looks at if someone is feigning psychosis in particular. On that measure, there's 25 essentially questions. So I ask a question, he gives a response. Some of those questions are also about asking if this person has experienced a particular behavior and seeing if their report is consistent with the observation in that room at the moment. So on this measure, he was below the cutoff, which is important. That's the number one thing that I look at. The second thing was looking at the symptoms that he did endorse. What were they? And those symptoms for him was feeling depressed, feeling like his life did not matter. So those things that he did endorse, even though they're used with other questions to determine if someone's feigning, those questions were really not of concern. One, because they were below the cutoff, but also because those things made sense given his particular situation.
So as a result of the MFAS you described, was it a result of that testing, there was no evidence of malingering?
That is correct. I did not see any evidence from the test, from my interviews with him, from the jail records, the RDC and Newcastle. So my review of the information was there was no information indicating that he's been feigning or malingering.
And did you also administer a test with an acronym TOM?
Yes, it's called the test of memory malingering. It fits in the category where looking at is someone feigning memory impairment, or are they putting forth less than optimal or less than ideal effort.
And based upon the results of that testing, did you find that he was in any way malingering or feigning the memory deficits?
I did not. And so that test, you look at two different things. One is their score above or below the cutoff? His score on that test was above the cutoff. And so the second step was his response below chance. So below chance is if you flip a coin, there's a 50-50 chance it lands on heads, 50-50 chance it lands on tails. So you look at when someone's responding to questions, if they are below chance, usually that's an indication that they know the answer to the question, but they're not giving the right answer. And he did not fall below chance, and which indicates that he wasn't feigning memory impairment. The important thing with both these measures is we don't, as psychologists or psychiatrists, we don't say someone's malingering based on one thing. It has to be multiple data points. And so with him, there were no indications on the testing, no indications, again, with the record review or based on interview.
And I want to talk to you a little bit about drug use as it relates to Mr. Dorsey's case. In reviewing the records and his statements, there was evidence that he had used marijuana that day, correct?
That is correct.
And I'm assuming that one of the things you want to do when you're conducting a forensic examination is to determine whether or not the symptoms are due to a mental illness versus perhaps some type of drug use.
Yes, that's critically important because if it's related to drug use, then that does not meet criteria for the mental disease portion. So that's a different situation altogether.
And what were some factors that you considered in determining whether or not these symptoms were due to drug use?
When I read over the case materials and I started meeting with Mr. Dorsey, that was one of the diagnoses that I put out there for consideration. Brief psychotic disorder, cannabis-induced psychosis or marijuana-induced psychosis, and then schizophrenia. Those were the three things that I was considering based on the preliminary data that I had. The factors that I considered when looking at cannabis-induced psychosis specifically, I looked at how long has he been smoking marijuana. So from age 13 until 24, 25, he said on an occasional basis. From 24, 25 until this incident, it's about 28 years old, 3 years he'd been smoking on a daily basis. When this is when I'm gathering history, not when we're talking about the incident itself. I start asking questions, like what's your normal reaction when you smoke marijuana? He said he's calm, he's relaxed. He said he used it to manage a lot of chronic pain. The other questions I asked at that point were if he'd ever had any bad or adverse reactions. And I asked that very openly. I don't cue about what I'm looking for. And I asked him that. He said he's never had any bad reactions, adverse reactions. And then I'll ask more specifically, have you ever gotten paranoid, had any problems like that? And he said no. So part of it is, 3 years he's used, has not had any adverse reactions. The other factors that I looked at, he said he got the marijuana that he was using around that time from the same individual he always got it from. He said he usually got top shelf from California, and he had said he's never used laced marijuana. So I also looked at those indicators.
Is also the severity of the symptoms documented and the persistence of those symptoms after the drug use ends important in determining whether or not the symptoms are caused by drug use?
Absolutely, and some of it's timing and some of it's severity. So you have an individual who's been smoking for 3 years, had no prior negative or adverse reactions to marijuana. And then you have that he had used that day, but prior to that he had he was showing signs of psychosis even before using on that day. And then I just lost my train of thought. Could you ask your question?
I was just, you mentioned one, the severity of the symptoms is something you consider, and then how long the symptoms may persist after it's documented that the drug use is ended. And my question to you, are those two factors important in determining whether or not the symptoms are caused by drug use?
It is important. Typically, someone may experience psychosis from cannabis during the intoxication period. So that's usually a few hours, maybe longer. And then it subsides. Other individuals may experience psychosis after using cannabis, and it could last a few weeks or longer. But normally, you don't see this level of severity, and you don't see it last as long as it did. So those are some differences.
And even though we're talking about a brief psychotic disorder in Mr. Dorsey's case, the RDC records would document that this went on at least until he was moved to Newcastle, which was basically at the conviction.
Correct.
And then I think you also mentioned in questioning him about any adverse reaction. Is that significant? Because if he had a documented history of adverse reactions, that, like paranoia, that may be an indicator to you that this was related to drug use.
Yeah, if someone's had that reaction in the past, it makes them more likely to have it in the future. So I ask questions about that because I'm trying to differentiate what's the cause here. And the fact that he hasn't had adverse reactions was, essentially using the same marijuana he's always used. The other factor that was really important was he said, and Ms. Brown also said, that they smoke the same marijuana. So if it's going to be so strong that he is becoming psychotic from it, I would also expect her to have some reaction to it. It doesn't mean it would be the same, but you would think that she would notice something as well. So that was another important piece of information.
And just finally, again, I just want to return very briefly to the interrogation video, the pre-interrogation video. And you've seen that video, correct?
Yes, that's correct.
Would you describe his behavior during that video as extreme?
There are certain portions of it that were extreme, particularly when he was sitting in the room by himself.
And if somebody is suffering from a psychotic belief, as Mr. Dorsey was, that somebody was going to kill them, and they felt that belief strongly enough that they would take deadly force to defend themselves, would the recognition that they were mistaken in that belief, based upon your experience, cause a significant or extreme response?
It could. Watching that video and then after speaking with him about it, what I see is an individual who is still psychotic, still thinks these things are absolutely true, but is also starting to struggle with the reality of what happened. And you can see kind of that struggle, and both those things are going on at the same time.
And the existence of that struggle, in your opinion, is that further evidence that he was psychotic when the video was occurring and psychotic at the time of the incident?
Yes, that's correct.
I have no further questions.
Thank you, Judge. Afternoon, Doctor.
Good afternoon.
I just want to clear up one thing before we start. Mr. Dorsey was moved to Newcastle May 6th, 2020, correct? You just kind of went along with Mr. Casanova led you there. I just want to make sure we're clear. It was beginning of May.
I have the records documented of when he was there. It looks like the discharge summary is from May 6th. So yes, you are correct.
Okay.
It looks like he would have gotten there. They did say he was moved there on May 6th.
So in your report, you said he doesn't meet the criteria for a mental defect. You read Dr. Gurr's report about the brain scan, right?
Yes.
So I just want to make sure we're clear here. What you're saying is that even if we do accept Dr. Gurr's conclusion about the brain shrinkage, the damage that he reports isn't in and of itself going to cause delusions, right? That's a separate issue.
Yes, correct.
Okay, so the brain shrinkage might make you bad at word games or graphic pictures, but it's not going to make it automatically that you can't tell the between right and wrong. The right and wrong is a separate issue.
Yes, right and wrong is separate.
Okay.
So, of course, the first issue is someone having a mental disease or defect, and if one or both of those are present, then the next thing is, did that impair or did that make them unable
And
to
you're saying
appreciate
the defect
wrongfulness?
with regards to the brain scan isn't a mental defect as you understand it under Indiana law.
That's correct, because the requirement has to grossly and demonstrably impair perceptions. And in this situation, what was causing those impairment in perception were the delusions,
Not
so the
right.
mental disease.
Sure.
I think the defect made it harder for him to contend with the
We covered that, yeah.
situation,
Um,
but
So
it
with the
did.
brief psychotic disorder, you identified a number of triggers that you walked through. The first one, really the big one, was the end of his football career, right? That's sort of that stress, one of the stresses that builds up, right? So you said the end of his football career is being concomitant with the loss of his identity. What does that mean when you say that?
Well, most individuals who have played sports for, he's played football since he was 5 years old. It has been an important part of his life and his identity.
Sure.
And he described being involved in coaching, mentoring, playing in college. And so when that ended, that's a significant part of how he sees himself and how he interacts with the world. So a big piece of his identity is sort of gone and over.
So it's interesting you mentioned coaching though, because I understand his playing days are over. On Thursday, his dad, his two brothers, and two football coaches come in, and everybody says, Eliahs is a great coach. We watched videos of him giving pep talks to the kids, we saw photos of him at community day with his players. So it was presented to us on Thursday that his identity as a football coach, that's what he lives for now. They claim he had snacks in the trunk of his car on the day of the shooting for the football. So did he lose his identity or not? Because we heard some conflicting testimony on Thursday that really his identity was still pretty well solidified as a football guy.
He was coaching and involved, absolutely. And so I think his identity started to shift in that way, but coaching is very different than playing. And again, it's not just that piece alone, it's that in combination with the other stressors.
Sure, yeah. So you also mentioned his mother's illness as a stressor. Again, on Thursday, we heard from Dad, two brothers, his brother's fiance, his ex-girlfriend, two football coaches. Nobody mentioned his mother's illness. So it didn't really seem to factor in their interpretation of what might have been going wrong with the defendant. But you mentioned that in your report as a potential stressor.
Yes, that's correct. When I talked with family, they had cited that, and then in some of the other documents it was mentioned, and then he discussed it as well.
And then you also talked about loss of employment due to the pandemic. We heard from Elliahs Brown that once the pandemic starts, he was basically sitting around in her apartment, getting high all day, freeloading with his new girlfriend in her new apartment. So that to you identified as a stressor. That now is how he's living his daily life.
Yeah, he indicated that he was upset about losing his job. And so how he acts after that, I can't necessarily speak to, but yes, losing that job in particular during the pandemic was one of the stressful events he encountered.
You testified a minute ago about substance-induced psychotic disorder. We heard some testimony yesterday about the fact that if you have a predisposition for some type of mental illness, controlled substances can exacerbate the effect of that mental illness. Do you agree with that?
Yes, so if someone, say, already has a mental illness and they use substances, it can exacerbate things.
So when you said two people might use the same substance, you'd expect the same results. That a caveat to that would be if one of those people is already suffering or experiencing symptoms of mental illness, it might amplify those in one person and not induce any effects like that.
It could potentially.
You also mentioned that drug-induced psychosis isn't a mental disease of people.
Well, it depends, but normally it's not characterized as a mental disease.
Okay. You talked about the defendant's grooming as being one of the sort of precursors that you saw at the onset of the psychosis. So, talking about guys had a bad breakup. Family notices that he's no longer as fastidious about his hair, he's no longer clean shaven, he sort of lets his appearance go. Does it matter to you when you look at that sort of change in grooming habits as a possible symptom or a precursor to psychosis that it came on the heels of a bad breakup?
I think the bad breakup was one of the stressful events that he was experiencing, and there are some individuals that, they sort of get depressed and down after they break up, but it wasn't, it was that in combination with family and Miss Davis also noticing that he is growing increasingly paranoid and saying strange things. So it's that combination. And based on the information I have from the records and from family and then from interviewing him, there was a direct link there. It wasn't just that he's down and sad about the breakup and so not attending to his hygiene.
Yeah,
I think it was way more than that.
The start of COVID too, I mean, everybody's probably a little shaggy, not hitting the barber as often, right?
That's a possibility, but I think in this specific situation, it was an indicator of much more, and it was one of the signs that his mental health was starting to deteriorate.
You mentioned Bianca a second ago. You talked about him going to her house. Now you said in your statement that he always carried a gun. The times that he was showing up at her house, he was armed, right? And he noticed that she didn't want him there because of COVID. So just to be clear though, when he shows up at her house the week before the shooting, he doesn't force his way inside, right?
Not based on her description,
He
no.
doesn't threaten her with a gun, right?
Correct.
He doesn't violently confront her about these accusations, these wild accusations he's making that are not based on any type of fact. He doesn't actually confront her physically, he's just texting and talking about them, expressing those concerns, right?
Right.
So
That's correct.
He doesn't, Bianca never reports that he crosses that line and becomes violent with her, or actually physically harms her, or physically threatens her, or points a gun at her, or anything like that, right?
No, she said those things didn't occur during that time or their relationship. She was more concerned about him showing up, him describing paranoid things,
Sure.
him at that point in time, I think it was the last visit, he also had a bulletproof vest on, which again didn't make sense given the situation.
Sure.
So
that
some
whole
of
thing,
the
he's
other
saying on the right side of the
indicators.
line in terms of his conduct. He's concerning her, but he hasn't actually harmed her anyway, right?
Yes, there's no information that I have that indicated he harmed her.
You sort of broke down some of the signs in your report between events before the shooting and events after the shooting. So I want to start with before, specifically the 911 call. So the defendant told you that he didn't think that Aisha was on the phone with 911 initially, right? This is all on page 35.
During the first call,
Yeah. And then he took the phone, and this is a direct quote from the defendant, made sure she was talking to 911 to make sure she was calling the police. Is that right?
yes, which paragraph are you looking at?
I'm sorry, I don't have it in front of me. It's,
Oh. Yes, I
fourth
found it.
paragraph.
Yep, found it, thank you.
So initially, oh, and then he says, this is a direct quote, I talked to the operator and I said someone was trying to kill me, right?
Yes, and so that's when I'm interviewing him and asking for him to go through details of what happened at that time. Yes,
And
that's
that's
correct.
sort of borne out by the transcript of the call, where first it says you're not the police, says it twice, and the guy says, this is 911. He says, oh, okay, well, somebody's been trying to kill me all day, I've been trying to call. So it looks like he initially is mistaken. He thinks that Aisha has called somebody else, right? That's his initial interpretation of this phone call. But then he gets on the phone, and he says to you, he confirms that it's 911, right?
Yes, he said that, but then he also indicated that he didn't think it was police.
Sure, but afterwards
Right.
he says he does get on the phone.
Yes,
and confirms.
yes.
Yeah, so he confirms it.
Mhm.
And then he says, okay, well, officer, I tell the operator that somebody's trying to kill me. So in this call, he has a mistaken belief. He acquires new information when he actually gets on the phone, thinks through it, and then says, okay, well, now I am going to tell this operator, who he calls officer, somebody's trying to kill me. So in this brief moment, he's acquiring new information, processing it, and then acting accordingly to try to get this call for help, right?
That's difficult to answer because
That's what
that,
he does.
well, I need to finish my sentence. So, yes, that is what he did in the moment, but then he also is still thinking that she is trying to kill him and
Sure.
thinks someone is coming after him. So it's not as simple as, oh yes, they said it's an officer's 911, he knows it's 911, it's all good, nothing else is going on.
Sure, but in that moment, he's able to think through the conversation he's having with the dispatcher.
To some extent, yes.
So then here's a knock at the door, right? He relates to everybody that it's a soft knock, and he reasons that, normally the police, they announce themselves, they're kicking your door, so this can't be sort of the theme of his kind of analysis on what he thinks when he hears the knock, right?
Yes, but right before the knock is his belief that Aisha was on the phone
Sure.
with someone and says, "Come get him."
Well, she was on the phone with somebody to come get him. to be
Right,
clear.
right.
It was just the police. that
Right,
come
but
get
his
him.
interpretation is
Sure.
that it's not the police she's talking to, that it's someone else she's on the phone with, and she's saying, "Come get them." And then within seconds, the knock, and he thinks that that knock is the people she called that are coming to kill him.
Yes, so he hears the knock, he analyzes it, he says, "Oh, it's quiet." He says, they don't say, "Hey, police, open up." Immediately afterwards, with Detective Prater, he actually mimics the knock on the table. He describes it again. He's real clear, he's real analytical about the fact that it couldn't have been the police, because here's how the knock occurred, right?
Yes, I remember hearing him describe that to the detective.
So in your experience, somebody who is going through the throes of this brief psychotic disorder, is their recall going to be that good?
I mean, the psychosis may or may not affect recall or memory.
Okay.
I mean, he's interviewed within hours of this incident.
Sure.
And then when I talked to him about it, he's already, had months to think about it, talked to his attorneys about it. So it's not that surprising he has recall. I also think afterwards he's trying to make sense of what just happened.
Sure.
But someone can be psychotic and still remember what they thought was happening.
Okay. And actually, that wasn't even what he thought was happening. That is a correct recollection. I mean, all the police officers said the same thing. Yeah, I knocked once, it was quiet, we weren't announcing or anything like that.
Correct, and that matched what Aisha said as well.
Yeah. So then, if he's able to have that good recall, not just of what he's believing, but of actual events that transpired, does it cause any concern that this story that Aisha was holding at gunpoint doesn't come out until later on when he's talking to the doctors?
I don't know who else he told prior to that, or who he had talked to.
Sure.
It was my opinion when I was meeting with him, and he said that she pointed a gun at him at some point. I thought that was more of his paranoid beliefs and delusions.
Okay.
There was no documentation that had happened. It could have.
Sure.
But his description of it didn't match up with everything else, and that also seemed to be part of the paranoia.
The reason I ask is because from that initial description of that knock to, exiting the apartment, shooting Aisha, in that initial statement of Detective Prater, he's really hewing closely to the facts. But then out of nowhere, in these reports, all of a sudden, Aisha was pointing a gun at me. So I didn't know if that was significant to you that now there's this sort of new story about what transpired in the apartment.
Well, I want to be clear, when he had indicated that she pointed the gun, that was earlier in the day. When he was telling me about it, he wasn't saying that happened in the moment before he fired through the door or before he shot Aisha. He was chronicling what happened throughout the day, and he had indicated that happened
Sure.
earlier. So I don't really make a lot of that discrepancy. Again, I don't know if that really happened or not. When he described it, it seemed like that was more related to his paranoia and psychosis than happening in actuality.
We've heard a couple versions of this, so I'm curious which one people view. We've heard that he was about to leave the apartment, that he's gathered his gun and his belongings, and he's making for the door, and he's about to be home free, and that's when he hears the knock, and that's when he has to start shooting. We've also heard this recollection that, no, I was too terrified to leave. I knew that if I poked my head out into that hallway and I exited this building, I was going to be killed on sight. So I'm sorry if I'm missing your point. I'm just curious which version of events he gave you.
If you'll give me a second to just
Sure.
look over so I can make sure and quote that exactly. So looking at this, I don't see that he told me either of those things.
Okay. I'm talking about the events after the shooting. You mentioned a second ago on direct that you thought his reaction was officers burst through his door with rifles, he's been handcuffed, he's been shackled, he's been carried out of the apartment, he's been put into an interview room where he knows he's going to be questioned about the murder of a police officer. Isn't that a situation that would elicit an extreme response from somebody who is not mentally ill?
Potentially. The thing that were notable to me about that was that he continued to say some of the psychotic things that he had said previously. And so yes, I think anyone in that situation would probably have a pretty strong reaction. It's stressful, scary, it's all of those things, but his reaction also included psychotic statements, and I think he was still in that psychotic state. So it would be a little different.
Disbelief that he'd done.
I wouldn't say disbelief, but he continued to make statements about feeling like someone was coming to kill him, but you could also see that he was starting to come to a realization that, the officer was hurt or deceased.
When
So
do you think he came to that realization?
I don't know exactly, but you could see him start to struggle with that during the interview. And in my, when I interviewed him, he did indicate that when he walked out the door, he saw the officer. And, so I think at that point, he was aware of it, but still very psychotic.
Okay. You said in your report directly after the arrest, Mr. Dorsey expressed paranoia that officers injected with syphilis and he believed officers cut his wrists and used a knife with a razor knife. So I went through the record and it looks like the first report of that was at the Marion County Jail on April 11th, where he tells, I don't know if it's a nurse, I can't tell who made the handwritten note, but that's when he first says he reports being injected with syphilis and how it raised at the time of his arrest, right?
Yes, that was documented in the Marion County jail records about him believing that they had injected him with syphilis. And then that was, yeah, and then that was also documented in the Marion County jail records about how he thought that they had cut him with razors. And when I interviewed him, he described that same thing. And then when you can hear on the 911 call where he's saying, like, don't shoot me, don't hurt me, it wasn't the same content as him saying, you gave me syphilis or you're cutting me, but there were still concerns that he was going to be harmed.
So he just killed a police officer. They enter his apartment, there's a gun laying next to him. Should he not have been concerned that he might be in danger from the police hurting?
Absolutely, on some level, I think so.
He's
But
yelling like, don't kill me, don't shoot me. That's not, you don't classify that as psychotic behavior, right? That's
yes and no, and what I mean by that is the way he was saying it, and in context of everything else that was occurring, I think there was a legitimate fear because that has happened. But then I also think that he was still psychotic and paranoid at the time. So I think it's both.
okay. With regards to the claims of syphilis and razor blades and stuff, on that second 911 call with the phone, it's just laying there. He correctly identifies that he's in danger from the police. He correctly states that he's in handcuffs, and he correctly sort of updates that to say they have him in white shackles. So he doesn't make any claims of actually being sliced up or injected right away, right? That's not in the 911 call?
That's correct.
And then he sits for hours in this interview room where he repeatedly has detectives come in and he's complaining that his cuffs and the shackles are too tight. He has them loosen those up. Doesn't make any mention there, though, that he's being intentionally sliced up with razors or injected with syphilis or anything, right?
Correct. I think the first notation of it was in the Marion County jail records.
Okay. You mentioned his flat attic that is sort of documented throughout those jail records. Can that be a normal response to trauma in people?
It could be.
Okay.
I think if that was the only thing that was described in those records, the records of Marion County Jail and RDC, I wouldn't have thought much of it, but it's that in combination with the other symptoms.
You also made note of his hypervigilance, sort of pacing, just his behavior in jail. I mean, you can imagine that jail is probably a scary place for somebody who's just been arrested for killing a police officer, right?
Yes, correct. But the pacing was also noted by Aisha earlier that day. And so I think for him, and in this situation, it has more meaning than just it's the first time I'm in jail and I'm scared.
You also noted some bizarre behavior at the jail. So that includes a report on June 25th that he was boastful about being involved in a high-profile crime.
I don't remember reading that he was boastful. Do you know what day that was?
Yeah, it was June 25th, 2020. It was page 386, the Newcastle DOC records. It was reported after a site session.
I don't recall reading that. I'd be very surprised
And
by
you can read it
that.
if you want.
No, I'm not questioning whether that was documented. That was not my experience during my interactions with him or my review of any of the other records.
Did you ever find it would be demanding or manipulative when you met with him? Because that's what they noted in the Newcastle records, that occasionally he behaved that way.
Right. So out of the Newcastle records, there were 2 days when it was noted that he was demanding. The other note said something about him being flirtatious.
Yeah.
So yes, I took note of those. That was 2 documents or 2 notes saying that compared to lots of pages that were still describing him as paranoid and otherwise. I also think the timing of it was that was, I believe that was in June when his symptoms have subsided. That was also inconsistent with my observations of him throughout all the interviews.
Okay. Somebody who has that brief psychotic disorder, that doesn't mean that they can't tell the difference between right and wrong in all situations, right?
And it doesn't automatically mean that.
Okay.
I mean, that's part of the analysis, is looking at, in this particular individual, in this particular situation, with brief psychotic disorder, could he know right from wrong?
Sure. And then you talked about how your evaluations can't go back in time. You said what's most important is what's happening in the moment and what's being said in the moment, right?
I'm not sure what the context was, but in these evaluations, yes, I look at before, during, and after. What is most important is what is happening in the moment. I mean, that's the statute at the time of.
Sure.
So that is certainly the most important part of the analysis.
And that's why you said something like the 911 call is a record of what happened on that day is really important.
Right, absolutely. Again, it gives a window into what's being said, which tells me what he's potentially thinking and feeling in that moment.
Another question.
Redirect.
Just briefly, Dr. Callaway, just in response to some of the questions you were just asked, when you talked to Bianca Davis, she did describe symptoms or actions by Elliahs that were concerning her.
Yes, it was above and beyond just hygiene. There were other behaviors that were very concerning to her.
They included accusing her of being pregnant.
Yes, accusing her of being pregnant, saying paranoid things, looking crazed. Those were some of the words that she had used.
And your review of her statement interviewing her, you would agree that those statements are consistent with psychotic beliefs on his part?
Yes.
And then we're talking, and those statements and beliefs continued up to the night before, where she does send a text message to his parents, correct?
Yes.
And then the next day, I think you had information from his brother that he received a call from Elliahs expressing concerns about the safety of his family.
Right.
And then during that day, Aisha, in statements, reported the
Objection, Judge, if we could get one non-leading question. I'm trying to be patient, but
You just objected that it's a leading
it's a leading question.
Okay. You want to rephrase?
I'll rephrase. So the next day, in the statements from Aisha, were those consistent with beliefs about being killed?
Yes, he was reporting that to when he was talking to his family the day of when they were on the phone, the 911 call, and then Aisha said that he was describing those same things.
Would you characterize these psychotic symptoms as increasing over the period of time in his interaction with Bianca, his interaction with his brother, and his interaction with Aisha?
Yes, based on reviewing the records, you could see a significant increase in those symptoms over time. They sort of started off slowly, which is what usually happens, and then within that week and then that day, they had peaked.
And just going back to some questions about the 911 call, the prosecutor talked about Mr. Dorsey acquiring information in the 911 call. Based upon your evaluation, even after that first 911 call, was Mr. Dorsey still concerned about being killed?
Yes.
Based upon what you reviewed of the information, was that concern ongoing even after that 911 call?
Yes, you could hear it on the 911 call that he was concerned about that. Aisha's statements and depositions showed that he was continuing to be concerned about that. And then even when he talked with law enforcement during the interview, he was still concerned about that.
Would you describe that psychotic belief that he was going to be killed as increasing over that period of time?
Yes, I think that you could see it with everyone's description of what was happening that day and listening to the 911 calls, that his concern that he's going to be killed was increasing throughout that day and in the days leading up to that incident.
The prosecutor kind of mentioned about the knock on the table that Elliahs does during the interrogation at the request of the officers. Based upon your evaluation or your review of the records, did Mr. Dorsey say something specific before firing through that door when he heard that knock?
He said that he just fired. That's what he had told me, and that's what I've gleaned from all the other records.
Was there information in the deposition of Aisha regarding what he had said before firing through that door?
That it ain't police, essentially.
The prosecutor mentioned to you about different versions of what Elliahs said happened that day. In your interviews with him, was it your opinion that he was, well, you've already said he was not malingering, correct?
That is my opinion.
Was it your opinion that he was lying to present himself in a better light to you when he said those things?
No, I did not get that impression at all from him. There was some guardedness around discussing some of his symptoms and not wanting those to be viewed as psychosis, but I didn't get the impression that he was lying or not being forthright during my interviews.
In your opinion, was it more consistent with his psychotic belief that he was going to be killed that day?
And when you ask that, are you referring to when he said that she had pointed the gun at him?
Was trying to rob him.
In terms of pointing the gun, I don't know if that happened, but based on the information I have, it seems like that was more his misinterpretation of what was going on because he was psychotic.
And just finally, I want to ask some questions about the entry in the Newcastle records. I'm assuming you have some familiarity with healthcare providers and prison systems.
Yes.
And that's the system. And those healthcare providers that come around and conduct these interviews, are they typically trained as forensic psychologists?
They're not usually forensic psychologists. If they're psychologists, they're what we call correctional psychologists, meaning they work in prisons or jails. Social workers that work there, there's more counselors that work at prisons, there's psychologists, psychiatrists, so I'm not sure exactly who said those things or
So
who
we-
documented those things.
We don't know the level of training of the person that made those entries?
I don't know the answer to that. That's correct. I don't know their level of training.
We don't know if these were, how long these interviews were,
I don't know the answer to that. Correct.
or how many other people they had to interview immediately after.
Correct. I don't know.
And will you agree that one of the primary concerns in the prison is security rather than treatment?
Yes, I mean, that's a difference between prison and a treatment facility or a hospital. I mean, security is first and foremost, and then the other things come after that.
And you've already mentioned the thoroughness of the work that you did in conducting the forensic evaluation in this case. In your opinion, is that type of thoroughness critical to ensuring that there's a complete, fair, and impartial evaluation of the person?
Yes, absolutely. The thoroughness is paramount in these evaluations. I think the other important thing to note is that people have different roles. Someone's role as a counselor at a prison is different than someone doing these types of evaluations. I mean, just by virtue of their job, that's a different role.
I have no further questions.
You crossed?
Nothing on that, Judge, thank you.
Ladies and gentlemen, do you have questions for this witness? I see it was Tanya.
Yeah. No, I'd be spinning probably all the speed we do.
Doctor, I'm going to ask you the question. Did you speak with the defendant's brother, Dow?
I did not.
Is there an age when someone typically gets their first episode of psychosis or psychotic symptoms if they have a brief psychotic disorder or schizophrenia?
The typical age is usually late adulthood, so 18-ish, can go all the way up to mid to late 20s. That's what's most common is within that time frame.
Would a stressful event that happened 4 years before this event still contribute to his brief psychotic disorder?
I would say that depends. The stressors that, in my opinion, contributed to what was going on with him happened more recently.
For the TOM test for malingering, Mr. Dorsey fell below the chance for feigning memory loss. Is there a specific probability percentage that you obtained from this test?
So the first step is he above or below the cutoff? And so he was below the cutoff on that test. And then the next calculation is, was he below chance in responding? And he was not below chance. I don't have a specific cutoff for, I can tell you what his score was, but I don't have a specific cutoff for that portion. I just know he was above chance.
Okay. Can you give him the score?
Yes. So on the first portion, how the test works is there's 3 parts. The first part, there's 50 items that you show them. And so you go through, show them 50 items, and then you have them look at two pictures. One of the pictures is something they've seen before, the other one is not, and you ask them to indicate which one they saw. So you go through that full set, so the 50 items. Then you show them the 50 items again during the second trial. And then after that, you again show them two pictures, one they've seen, one they haven't. And then there's a third trial, which is just where you show them two pictures and you have them pick which one they saw before. So 50 each time. His first score was 22. The second score was 33. So part of what you're looking at is their score in total, but then also, is there any learning? So he got a 22 the first time, next time is 33, which is a higher score. And then the last one was 37. So again, looking for learning, and then those were still, the last two were still above the cutoff, meaning that it was not below chance. Hope I answered that sufficiently.
Did you ever ask Mr. Dorsey if he was wearing his bulletproof vest during the incident?
I did not ask that question.
All right, so you don't know whether he was wearing it or not?
I didn't see any documentation that indicated, but I did not ask him that directly.
How does Mr. Dorsey's paranoia dating back to late 2019, when he's wearing the bulletproof vest, how does that relate to the brief psychotic disorder?
It relates because there was an escalation and an increase in symptoms for him. He was experiencing, you could get a sense that the paranoia was developing based on what family and friends had observed. And so for me, that's important because you want to see, when did the symptoms start? What was the initial severity of the symptoms, and how did that compare to what he was experiencing at the time of the incident?
So was wearing the vest a sign of the disorder's onset, or was it a trick?
I would characterize it more as a sign of onset versus a trigger. I think he started wearing the vest because he was increasingly paranoid that something was going to happen to him.
If Mr. Dorsey still believes in his delusions from years ago, why is it considered brief psychotic disorder and not schizophrenia?
That is a very good question, and that's one of the reasons I listed schizophrenia as a possibility. When I met with him, there was clear documentation that he had psychosis around the time of this incident. Reviewing the jail and RDC and Newcastle records, it looks like there was improvement within about a month after. And so that's why I diagnosed brief psychotic disorder. But important things to note are that people can have relapses of brief psychotic disorder. People can also go on to later show signs that would be diagnosed as schizophrenia. So I haven't seen him in about a year. I don't know, when I met with him in 2023, he wasn't showing signs of psychosis in that moment. So based on that, I did not diagnose schizophrenia, but I listed it because it needs to be continually monitored to see if he does have another episode of psychosis that would meet criteria for either a relapse of brief psychotic disorder, or if he would just go ahead and meet criteria for schizophrenia.
Is there a different practice for looking for malingering between subjects who are currently in psychosis and those who are no longer experiencing psychosis? For example, a schizophrenic patient versus someone who previously experienced a brief psychotic disorder.
The assessment for malingering is similar in those situations, looking for how someone is presenting in the moment, and if they are showing active signs of psychosis, is that consistent with what we would expect to see when someone has psychosis? So it's the same assessment. There aren't a lot of major differences. It's what's, is the person showing symptoms that other people with, say, schizophrenia show? Is their description of things consistent from one time I meet with them to the next? And then also, is what they're telling other people consistent with what they've told me about their symptoms, and what other people are observing, is that consistent with what I've observed? So you're looking for consistency across the board, and evaluating that would be the same if someone has schizophrenia and they're overtly psychotic versus if someone had schizophrenia or a brief psychotic episode and they are now stabilized.
Approximately how many total court-ordered or defense-requested evaluations have you done throughout your career?
In terms of competency evaluations, determining if someone's competent to go through the court process, I've done about 1,500 of those since 2007. Probably 95% of those have been in Indiana. I've also done work in Texas and North Carolina. In terms of insanity evaluations, I've done right around 1,200.
And approximately how many of those evaluations have you reached the conclusion of insanity?
On the insanity evaluations, I don't know the answer to that over my career. I recently started tracking that. So last year in 2003, I did 140. Oh, so did I? Yes, 2023. I did 148 of those, and there were 8 where it was my opinion that someone met criteria for insanity. So I think that's what, roughly 5%.
Okay, and in how many of those were you found, when you determined someone was insane, have you testified to that conclusion?
If we're looking at just 2023, last year probably testified on 3 insanity cases.
What led to the decision to interview Bianca Davis for insight in terms of recent behavior, hygiene, etc., but only rely on recorded statements for Elliahs Brown?
Since she is a victim in this case, I don't customarily reach out and talk with victims. Since my evaluation was requested by the defense, that is normally limited. If it's court ordered, it usually has to be agreed on by both parties that would be acceptable because they are a victim in the case.
Would major depressive disorder with delusions render someone more likely to appreciate wrongfulness of conduct than a brief psychotic disorder?
No, not necessarily. The diagnosis is important, but what is most important are the symptoms that someone was experiencing at that moment, and psychotic symptoms are usually the type of symptoms that render someone unable to appreciate whether the wrongfulness.
Wouldn't surrendering immediately to the police indicate that he knew his actions were wrong?
It can be. That can be an indicator. In this situation, I did not think that was an indicator. I think in the moment that he fired his weapon, that he thought his life was being threatened, and then I think he still had concerns that police were going to come in and shoot him, and I think some of that was situational, and then I think some of that was psychotic. But him following law enforcement's request does not change what he was thinking about in that moment and how he was responding to his paranoia in the moment that the incident happened.
Did you discuss why Elliahs initially pulled Mrs. Brown back? Was it to protect her? And if so, why did he end up shooting her?
He didn't say anything to me from my recollection about him pulling her back. He had indicated that he thought she was still going to go out and get someone to harm him, and that's why he shot her. And then I paid attention to what she said about what happened and how he had told her, "You're slick," and that she thought, he believed she was part of a conspiracy.
Has Mr. Dorsey ever talked about Officer Leath? And if not, would that be concerning?
He has, and if not, that could potentially be concerning.
That concludes all of the jurors' questions. Does the defense have questions on the jurors' questions?
Dr. Callaway, is it fair to say, well, are the majority of the times that you testify in forensic situations, including insanity, the result of court meetings?
Yes.
That's all, Judge.
Questions on either the jurors or the defense questions, Dave?
No questions, Judge.
Ladies and gentlemen, do you have further questions for this witness? All right, I don't see any hands on that. Mandy, you may step down.
Thank you so much.
All right, defense, you may call your next witness.
Judge, at this time, the defense has no further witnesses.
All right, ladies and gentlemen, that completes all of the witnesses on behalf of the defense. Does the state wish to present any rebuttal at this point?
No, Judge.
All right, ladies and gentlemen, we are going to take a brief recess. Well, the standard recess. But you should know that under Indiana law, when a defendant raises the defense of insanity, the court is required under Indiana law to appoint disinterested psychiatrists and psychologists, meaning that the court pays for them as opposed to either of the parties. And so the court's required to appoint disinterested psychiatrists and psychologists to examine the defendant, and I'm further required to call those psychiatrists and psychologists to testify at trial concerning their opinion about the defendant's sanity. The fact that they are called as witnesses by the court does not necessarily mean that the court approves of their reports or sanctions their testimony. You're to consider and weigh their testimony as you would any other expert. And it is a part, once both sides have completed their evidence, by law, we then have the court presented psychologists and psychiatrists. So after the break, you will hear from a psychologist and a psychiatrist appointed pursuant to statute. And with that, we'll be in a brief recess. You're not to form or express an opinion about the guilt or innocence of the defendant, to refer to all of the evidence, the argument of counsel, and the court's final instructions. You may discuss this case amongst yourselves, provided that you're all together in the jury room. You don't go to the ultimate question of guilt or innocence. If anyone does try to talk to you about this case, you must report that to the court immediately. We'll be in a 15-minute recess.
All rise.
Record to reflect the jurors have left the room. Anything administratively, defense?
Yes, Judge, two issues. The first, we did not formally rest just because I wanted to, I think the court did yesterday morning take judicial notice of the state's January 24th, 2024 motion to dismiss, but I couldn't quite remember for certain, and before we rested.
You'll notice I said to the jurors that this included your witnesses. Okay. So I wondered if you were going to get to that point or not.
I was going to raise it, but I didn't want to go to the bench. I preferred to do it.
Okay, I don't consider you're foreclosed. You all may be seated. I don't consider you're foreclosed from doing that. At this point, I realize you may have not, but I understand the distinction. Okay, anything else?
How is the court handling the defense motion to exclude Dr. Truitt?
We're going to do Ross first, so I get him out of the way. And then I assume when I call Truitt, I assume that you'll make your motion at that time, and we'll have that portion of the hearing outside the presence of the jury. Okay?
Thank you, Judge.
Anything from the state?
So just so I'm clear, what's happening with the motion to dismiss the death penalty? Is it going to be?
Is it? I guess is the court taking judicial notice of it?
We're going to make that record now. Okay. Anything else? Okay. All right. We discussed this yesterday, and both sides had an opportunity to make a record. The court gave some of its original indications or concerns, and I did allow for the possibility for you to supplement whatever record you wish, and so this would be that opportunity. Does either side have anything you wish to supplement in terms of either additional argument or case law?
defense does not have anything beyond the email that's sent to the court, I believe. And to the state.
The state?
Nothing in addition to the argument from yesterday.
Okay. Then in considering this issue, hang on a second, I've got my research on my computer, so pull it up momentarily. In considering this issue, I think I'm going to err on the side of not taking judicial notice. I think that, again, the case law being so devoid of criminal cases in this area, and given normally the extensive research that Miller on evidence provides, the fact that there isn't anything there, and the language of the Saylor decision with the Court of Appeals going out of its way while acknowledging that judicial admission is possible in a criminal case, going out of its way to diminish the practical effect of that. The court believes there's two different opinions in which you can characterize the state's pleading. I understand the defense argument as to what it means and that it's an admission, but I also understand the state's argument that it goes to the consideration of death penalty and not the issue of ultimate guilt or innocence, to which this jury would be considering, and that injecting that judicial admission and or giving it some evidentiary emphasis would lead, in my analysis, under a 403 analysis, to confusing the jury and not adding enough probative value to it, particularly in light of the requirement that under Rule of Evidence 201, I'd have to be telling the jury that they could ignore it if they wanted to anyway. And so I think for those reasons, I think in weighing probative value versus confusion of the jury, I'm erring on the side of keeping it out. And so that will be the court's ruling. I understand the defense would be objecting to that and preserving that if there is a record to be made.
And is the court then not going to allow the defense a jury instruction on the issue?
If I'm not taking judicial notice, I'm not giving an instruction on it now. Anything else?
Nothing from the defense, Judge.
State?
Noted.
All right, we'll take 15 minutes from now, and then we'll start with Dr. Ross. Again, it's the court's intention of asking the predicate foundation questions and then allowing both sides to cross-examine the reports. So I'll give both sides an opportunity on both doctors to treat it as cross. Because I think I indicated yesterday, because the defendant bears the burden on insanity, defense will go first as to both doctors. But other than laying the predicate foundation for the opinion and what the basis of the opinion is, the court won't go any further than that. We'll leave it to both sides to go through all those questions about whether such and such a piece of evidence or a statement is consistent, inconsistent, etc. The court won't touch those things. That'll be up to both sides to bring out to the jurors if you wish. Okay. Any questions on that process? And I will submit their curriculum vitae. First with Dr. Ross, that would be court's exhibit Roman numeral 1, and Dr. Trebet, if we get to Dr. Trebet, would be the court's Roman numeral 2.
bachelor's degree in history. I decided not to be a priest. I was a priest, and I didn't think it was going to be for me, which is what I was studying for. I got a master's degree in '82 from Michigan, from University of Dayton, and my doctorate in 1990 from the Illinois School of Professional Psychology. It's from a consortium, was a consortium of schools up in the Chicago area. I got my PsyD, PSY period D period PsyD in clinical psychology. I also am board certified in clinical psychology. Board certification for psychologists is one of the, at least here, it's one of the highest things you can get, and which is why I thought I need to do this kind of work. But I obtained that in 1997. And I've continued to do my training in forensic psych since I got my license.
And what is your employment history in the field?
Well, I'm the owner, president of Clinical and Forensic Psychological Services in Indiana, DC. I've been that since 2001. I have been doing primarily forensic psychology work in the state of Indiana. I do it up in Fort Wayne, Indiana, in competency stand trial, insanity defenses like this, and then some other cases that I get involved in. But this is most of what my work is nowadays. I trained forensic students in the past, doctoral students who come to Fort Wayne, so I got to pass that down to them. But it kept me trying to stay ahead of the game with what was expected of me to do this job.
Have you had previous opportunities to examine individuals to determine their competency to stand trial or whether they were sane or insane at the time of an alleged offense?
Yes, again, that's most of what I do. I do them in Indiana, in Fort Wayne. And I've done it since '94. And
Approximately how many times over the course of your career if you can give your best estimate?
300 plus. And now I'm doing them more often than not, like 3 or 4 a week. There's a real need for this kind of work, and for psychologists to be part of this. But this is mostly what I've done. And I do clinical practice. I keep my foot in the door to know how mental illness affects people in clinical settings. So I like to keep that part going too.
All right, I think the jurors have already heard the difference between a clinical psychologist and a forensic psychologist. And you have performed in both capacities, is that correct?
I have.
All right. And do you belong to any professional organizations related to your work?
I'm a member of the American Psychological Association, the Indiana Psychological Association, and I'm a member of the American Board of Professional Psychology. Again, I'm diplomated or certified in clinical psychology, so I'm a member of that organization.
And let me show you what's been marked as court exhibit number Roman numeral 1. And is that your curriculum vitae?
That is,
Okay. The court would introduce into the record the witness's curriculum vitae. As any objection from the defense?
No, Judge.
State?
No, Judge.
Okay. And someone in your field, are there continuing education requirements either as a student or as a teacher?
yes, for a licensed psychologist, and again, I'm on the board, so I have to see these applications. We have to receive 40 CEUs every 2 years of continuing education. COVID really put a dent in it because before COVID we could go off and get training. Now it's online or go to places, but I kept that training going on for up to this point.
Have you published any professional articles or taught in this area?
Well, when I was an intern supervisor at Park Center, that's a mental health center in Fort Wayne, we have a doctoral training program for clinical psychologists. I was a chief supervisor there, chair of the department. And then I trained about 8 or 9 interns, doctoral interns, for their further training in forensic psychology. They took a rotation, so I have trained before. I am training one person now who's a professor at a local university. She wants to participate in this and do this kind of work. But, that's the extent of my training of other people. I haven't published in a while. I'm just too busy to do that. I have in my VK here research experience and what I have published before in the past. Again, I'm also a member, I'm the vice chair of the psychology board, so I get to see what goes on in the field over the course of time and how things change, and they changed a lot. It also keeps me having to go back to school and pick up what the younger psychologists are doing.
And have you testified as an expert in court in your field of forensic psychology?
I have.
And approximately how many times and where would that have occurred?
Most of my testimony has been up in Allen County. I will also do some in surrounding counties. They refer a lot to me. I do get some counties north of here, but I do most of my work up in that area. So being one of these cases down here has been unusual.
Is that primarily in state or federal court?
State court, I used to testify in federal court. I don't do those evaluations anymore.
Okay. And specifically, have you had the opportunity to testify on the issue of sanity?
I have.
And when did you first become involved in this case?
Last year, early, I would think when I received a phone call from the court asking me if I'd be interested in doing this. They use their experts here, and they asked if I would be willing to take up the case.
And you are familiar with the Indiana definition on sanity or insanity?
Yes,
And also the mental disease and defect?
yes,
All right, and you've testified as an expert in that area for the times that you've already mentioned to the jurors.
yes,
All right, in this case, did you have an opportunity to examine Elliahs Dorsey?
I did.
And was that for the purpose of determining the issue of sanity or not?
Yes, it was.
And when did you first come in contact with him?
I first met the defendant at Newcastle Correctional October 9 of last year. Saw him for 3 hours, 40 minutes, and I returned there in November 14th of last year for a 2-hour, 45-minute interview. He also had some psychological testing completed there in his prison.
And what type of testing did you actually perform, and under what conditions?
Well, the conditions were I had a doctoral student, advanced doctoral student from Ball State, proctored the testing. The 3 tests I gave were the MMBI, the MCMI, then PAI. I needed someone to proctor the testing for this defendant, which is appropriate. Took several hours for him to do the testing, and then it was sent back to me by my associate who works with me through Ball State University.
Can you briefly describe to the jurors what the purposes of those various tests were?
Sure. Psychological testing, and I used some, threw some terms out, MMPI and whatnot. Psychological testing is supposed to assess the presence of any current mental health issues, like paranoia, depression, a whole range of psychological problems. And then, the 3 tests I did was designed to assess for that. I also wanted to know if there could have been not replications, but some indications of prior issues. Some of the tests I give, you can pick up a long-standing psychological problem. I wanted to see if that was present with this individual. Again, they were administered in the prison. He knew what he was doing. He had no problems reading or understanding the test questions.
And did you, prior to or during the course of your examination, did you obtain any background materials or source information about this case?
I did.
And from whom and what type of materials did you actually receive?
I received an awful lot of material, but an awful lot of material in this case. I wanted to focus on the materials that were more indicative of what was going on with him at the current time. So I did review DOC records, Department of Corrections records. I reviewed his records when he was here in Marion County in the jail. I also reviewed some psychological reports or evaluations done of this defendant by other experts. So I looked at that later on, but I wanted to focus on the present of this defendant. What was his state of mind at the time I saw him? And then going backwards, what was he going through and what was he like at the time of this incident went down?
All right, can you indicate to the jurors that the type of source material that you actually did receive and did consider?
Yes. From the defense counsel, I received I received charging information from the judge already. I received audio calls records from DLC, interrogation records of the defendant. Defense counsel also did interviews of family members, defendant's family, parents, and I believe of an ex-girlfriend. I reviewed the expert reports. I reviewed the DLC records, as I noted. I reviewed the police records, I guess, as it was taking place, their rendition, their recall of what had occurred when the shooting took place. Excuse me. I was provided some audio and video feeds, I believe, of the defendant. I reviewed when he was down at the jail, when he was first put in the interrogation room. I noted in my report that the first hour or so that I observed him, he was observed in a very frustrated state, very much crying. I wanted, paranoid at that point. The video cut out for me, so I didn't see after that. So I relied on what were transcriptions of what went down, either in the police reports or in what was provided to me by defense counsel. Let me see if I anything else here, please. Other than the police reports, I also reviewed the records of Dr. Calloway, Dr. Gurr, GUR. I believe they may have testified earlier. Dr. George Parker, reviewed a report from a Dr. Abukar, I believe. I had some records there beforehand that I could look at. I'm trying to find if there's anything that was done recently. And I think Dr. Parker's was the most recent report, I believe, or maybe Dr. Calloway.
Would the report and conclusion that you reached in this case, would that have been independent, though, of the information you received from the other doctors?
Yeah, I took their information in. I wanted to see what other angles were taken at this defendant. Then I came up with my own conclusion. I'm not here to support some other doctors.
You indicated there were testing done with the defendant. Was the defendant cooperative with those tests?
He's cooperative. The testing is also designed to tell me if you're being honest with me, if you're trying to fake an illness. Those tests can pick that up. They're also designed to tell me if you're being cooperative in the sense that you understand the questions and that you answer the questions appropriately. We're looking for consistency. I could not get a read on this defendant, a big read from this defendant, psychological testing administered to him. I even had a proctor there, someone to monitor it. I think he was avoiding self-disclosure. He was not giving me as much information. I don't know whether he purposely did that. I was able to get some symptoms of another test picked up with regard to PTSD, major depression. So I didn't see many problems in it now because this event took place about 3 years ago.
And were you satisfied that the testing procedures as you were using them were procedures were sound?
Well, they're invalid, and if they're invalid, I would like to be able to use them. So I'm limiting what I can say about this defendant based on my test results.
Okay. How much total time did you spend working on this case?
Oh, I took 2 weeks at a time. I had to take all this information that was given to me, and then spend time to go down to the jail, or to the DLC. It took up a lot of time. I had to review everybody's report and all this data together, which is good because when I get that information, I can look back retrospectively and see what might have been.
Did you have an opportunity to form or express an opinion as to the defendant's sanity at the time this offense was alleged to have occurred?
It did.
And what is that opinion?
I thought he had a brief psychotic disorder. I did not see him having schizophrenia. I think I read in my report, I don't think schizophrenia. I think he was delusional at the time this went down. He was not experiencing hallucinations. He was experiencing delusions. He had hypermotor activity. He was worked up a lot, as I noted but I thought it was brief psychotic episode.
So what's the basis for your opinion?
What went down that day, what did not occur before, he was experiencing some paranoia, probably some delusional thoughts. Some of them went way before this. I think it became worse. I've gone on out thinking about this before. He has been a regular consumer of marijuana. Some folks believe that doesn't affect our functioning. I think it does. Whether or not it caused this gentleman to have a paranoid state, I think it might have exacerbated it. I disagree with some others, but I think it was there. I said in my report that it wasn't significant, but I'm thinking that it was a contributing factor, which put him in a state of delusional thinking, hyperactivity, aggression, and then ending up not knowing what was going on around him, hence shooting the police officer.
Ultimately, did you include all of your findings in a written report to the court?
I did.
And have you had a previous opportunity to be posed or questioned under oath by the attorneys on both sides of the case?
No.
Okay. And with that completes the court's questionings of Dr. Ross. Mr. Casanova, Ms. Casanova, your question to this witness?
Yes, Judge.
You may.
Good afternoon, Dr. Ross.
Sir?
You issued your report on December 1st of 2023, is that correct?
Correct.
And in that report, you did evaluate Mr. Dorsey to determine whether or not he appreciated the wrongfulness of his action at the time of the offense.
Yes.
And also to determine whether or not he was suffering from a severe mental disease or defect at the time of the offense.
Yes.
And you testified earlier that you did find that he was suffering from a severe mental disease or defect at the time of the offense.
Yes.
And you identified that as brief psychotic disorder, correct?
Correct.
And you also offered a conclusion as to whether or not you appreciated the wrongfulness of his actions at the time of the offense. Is that correct?
That's correct.
And in your report of December 1st, you concluded that you did not appreciate the wrongfulness of his actions at the time of the offense.
That's what I wrote.
And I'm assuming you wrote that in the report, and that is your opinion, and it's still your opinion today.
Yes, sir.
I'd just like to talk a little bit about some of the sources that you reviewed and come to your conclusions. I think you testified that you met with Mr. Dorsey on at least 2 occasions. Is that correct?
Correct.
It may be for a total of over 5 hours, it looks like.
If that adds up, 3 hours and 40 minutes and 2 hours and 45 minutes, that's 5 hours plus 6 hours.
And you did testify that you did receive some documents. You did receive some documents for the facts, correct?
Correct.
And I think you talked about some of those. They included interviews with family members.
Correct.
As well as records from the Marion County Jail, the Reception Diagnostic Center, and I believe Newcastle Correctional Center.
Yes, sir.
And then you also reviewed a deposition from Elliahs Brown,
Yes.
as well as you did say you were given the interrogation video, but you did indicate that did not play all the way through, but you did read Mr. Dorsey's questioning by the police.
I did.
And again, just want to talk about some of the information that you relied upon in coming to your diagnosis, as stated in your report. And I'm looking at page 6 of the report.
I'm there.
There were, this is records you reviewed from Regional Diagnostic Center. This is the fourth paragraph there on page 6 of April 17th, 2020, in which there was a entry that he expresses few paranoid ideations, but still expresses the belief that he fears his family has been killed. Is that correct?
Yes, sir.
Also, the next paragraph down does include information that he questioned why he was not allowed to give a social security number and fears that he will be killed with no record. Is that correct?
Correct.
And this would be information that you relied upon in coming to your diagnosis and conclusions. Is that correct?
Some information, yes.
And then, in addition to the interviews we provided, the defense provided you with regard to certain family members, including his father, Larry Dorsey. There was also an entry in the RDC records about contact that they had with his father on April 22nd, 2020. This is on page 6 of your report, the second to last paragraph. Specifically, his father indicated to RDC that Elliahs was expressing concerns that people were trying to kill his family. He could not explain who or why, and he had been questioning his father whether he would die.
Yes, sir.
Also on that page 6, there's information, I believe, also including the report in the RDC records that he was urging his family to move. And that would be that would also be, I'm sorry, that would also be in that second to last paragraph as reported by his father, saying things like, we have to move from the area.
Where is that again, sir?
Second to last paragraph, it would be, sentence again, father said he had not noted anything wrong until the week of the officer's death. He
Yes.
said Elliahs had become paranoid, saying things like, we have to move.
Thank you.
Another source that or I should say another source that you did review and rely upon that were additionally in the RDC records. This is on page 7. It's the second paragraph. Entry on May 1st of 2020. Basically, that second to last sentence, still feels paranoid, continues to feel his girlfriend is trying to get all his stuff. And again, that's part of the records that you relied upon coming to your conclusion, correct?
Correct.
And then another record source that you reviewed would be records from the Marion County Jail.
Yes, sir.
And I'm looking at page 23 of your report. It is the last paragraph there, and it is the second to last sentence in which those jail records indicated that when corrections officers came into his cell to apply belly chains, he became distraught and yelled that he didn't want to be shot. Is that correct?
Correct.
also on page 24, which would be the fourth block paragraph. Also what you relied upon was a April 11th, 2020 entry in the Marion County Jail records in which Mr. Dorsey reported that the arresting officers had injected him with syphilis during his arrest, correct?
That's what I wrote, yes.
And I'm assuming that would have been what was in the records.
Correct.
You also relied upon, even though you weren't able to view the entire video, you did rely upon statements that Mr. Dorsey had made during the questioning by Detectives Prater and Howard. Is that correct?
Yes.
And I'm looking at page 11 of your report. And this would be basically the fourth paragraph, him relating that it just felt like someone was trying to kill me. It just felt too weird, correct?
Correct.
And then that next paragraph, looks like the third sentence, something was off the day of the incident. He felt like someone was trying to drug him or something. As he was being fingerprinted by law enforcement, he continued to express his fears of being killed, being set up. Again, that would be information that you relied upon.
Yes, I did. Yes.
And then on page 10 of your report, I'm looking at the 8th paragraph. Again, relaying information through the questioning that you relied upon, and that in particular, that throughout the interrogation, he continues to assert that he believes somebody is plotting to kill him.
Yes, sir.
And then additionally, this is on page 10 to 11 of your report. This also appears to be information that you provided during the questioning. He felt that, or he said to Detectives Prater and Howard that the woman in the apartment, Aisha, said, "You need to come get this guy." It was just weird. Like as soon as she said that, there was a knock on the door. And then she said, "Yeah, you need to come get this N word up out of here," correct?
Yes, sir.
You also as also part of the questioning by Detective Prater and Howard, you mentioned in the second paragraph on page 12, again, he stated to them that he thought about who was on the other side of the door when he shot. He said somebody that she had called up. She said that she knows a lot of family in Chicago, and she said, "Yeah, it's time for you to go." And again, that would have been information for the diagnosis.
Yes, sir.
You also provided by the defense the deposition of Aisha Brown, which you reviewed and relied upon in coming to your conclusions. And looking at page 10 of your report, this is paragraph 3. couple of sentences, which you stated. She noted that she heard 2 knocks on the door with law enforcement being present. When she went to the door, the defendant grabbed her and said, "That ain't the police," and started shooting. Again, some additional information that she relied upon.
Yes, sir.
And then you also listened to 911 calls. I think the court may have provided you with both of your 911 calls related to defense. And then I think the defense may also have provided you with a third 911 call involving a call made by Mr. Dorsey's office.
Okay.
Does that sound correct?
Yes, I remember the ones involving the 911 calls, but I don't know about the uncle.
Okay. But on page 14 of your report, you cite what is relevant in those 911 calls in supporting your conclusions. I'm looking at the last paragraph there on page 14, and I think you also got a transcript of those 911 calls.
Yes.
Basically, that first 911 call, Mr. Dorsey telling the dispatcher, "Bro, you ain't even the real police." And then going back to page 9 of your report, the last paragraph, there's an entry from that 911 call where he states to the dispatcher that he feels like someone trying to kill him, and he isn't paranoid about it, and that he doesn't need to go to the hospital. Correct?
So he said.
And fair to say that at least one of the sources that is important to rely upon, or would rely upon, is statements made by the defendant during the course of a clinical interview.
Yes.
Or a forensic interview.
Forensic.
And also, you certainly would want other information in terms of records and statements of other people related to the case. Would that fair to say?
Yes.
And you did receive all of that information in this case.
And that would have been what I would typically have asked for if I had done this in another jurisdiction.
And I'm looking at page 12 of your report. And I'm looking at the first paragraph on page 12 of your report. It appears to be a paragraph that is basically summarizing at least one of your conclusions based upon the information that you had received about it. Is that fair to say?
Yes.
And I look at this, if I'm correct, this would be kind of one of the conclusions that you made based upon the information leading to your ultimate diagnosis.
Yes.
And in that, you're stating the defendant then ties together the knocking on the door, which was the police officer, and the confirmation of his belief that somebody was trying to get him. Is that correct?
Yes.
And am I correct in interpreting that conclusion of yours, that the knocking on the door by the police officer was confirmation to him that someone was trying to kill him, someone other than a police officer?
Yes, because preceding that was this disagreement with Aisha, and then the brandishing of a gun. And as I get it from your client, it might have been that brandishing that set him off even more so.
And again, based upon your diagnosis, your conclusion was that this belief that somebody other than a police officer was on the other side of that door to kill him was based upon a delusion. And then, want to then look at the third paragraph on page 12, which I'm reading as a kind of second portion of your conclusion based upon your review of the information that ultimately led to your diagnosis. Specifically, that first sentence of that third block paragraph, the defendant pieced together that Aisha was on the phone talking to somebody, and the defendant in his mind was led to believe that that someone was out of harm.
Yes.
And I know I may be reading those as two separate conclusions that you made, but they are two conclusions that you made essentially that ultimately support your diagnosis and your finding that he was unable to appreciate the diagnosis.
Yes, he didn't believe that Aisha was calling 911. He believed that she was calling people to hurt him.
And in your opinion, based upon the review of the evidence, that belief was based in psychosis, specifically delusional.
Brief psychosis, yes.
And you also reviewed information, interviews with regard to a fiance named Bianca Davis, is that correct?
Yes.
And that, in those statements, there was information that she provided, that she observed with Mr. Dorsey the week prior, and particularly the evening prior to the event. Is that correct?
Yes.
And this is, some of this information is relayed in your report on page 13 of your report. And this would be kind of that fifth block paragraph where
On
Mr.
page
Dorsey.
on 13?
Yes, I'm sorry, page 13. Where Mr. Dorsey was believing she was pregnant, that she was accusing of having an affair with his barber. And again, that was consistent with the delusional belief, is that correct?
That's how I understood it. Delusional in the sense that I believe Miss Davis said that she was not having an affair with Barber and she was not pregnant.
And in the interviews that you read of family members, particularly his brothers and his father, Mr. Dorsey's expressions to them of concern for the life of the family and his life, from their perspective, were also not based in reality.
Yes.
That is statements or behavior that they felt was out of place or unusual.
Yes.
And you do cite those in your report, so I'm assuming that those are also facts that you relied upon coming to your conclusion.
Yes, sir.
The other issue, and this is on page 18 of your report, this would be the third paragraph. It's basically a review of information I believe you received from Mr. Dorsey's brother. So yes, it's the third paragraph. His brother also noticed that the defendant was wearing a bulletproof vest in early 2019 and he needed to stay ready. Again, something that, based upon those interviews from the perspective of his brother, was unusual.
Yes.
And in talking about brief psychotic disorder, is the criteria for brief brief psychotic disorder, part of it involved the presence of stressors.
Yes.
And in this case, based upon the information that you viewed, were you able to identify stressors, or I guess triggers, that were related or satisfied the criteria for brief psychotic disorder?
Well, I think one of the biggest triggers was his delusional belief he had about his faith. He was caught in that. And I guess it may not be delusional to think that she could be with somebody else. I don't know. In his mind, he really believed that she was, and from that he took upon himself the feeling that he could protect himself, and he got very out of control of his emotions, which all came together. Whatever amount of seconds it took for that to take place, he was building up before that time. I think some of what I referenced show that family members said there was something going on before. I think it just came to the head at that point.
Okay. I think looking at page 17 of your report, paragraph 3, you do talk about, and probably from the information from family, they reported a number of events that led up to this incident. You've already mentioned the breakup or the issues with his ex-fiancée, Bianca Davis, keeping things from parents such as the breakup and the reason for leaving Wilmington, and then COVID lockdown made things a little difficult. Is that correct?
Yes, sir.
Now, when you conducted your clinical interview with Mr. Dorsey, that was done in the fall of 2023, correct?
Yes, sir.
So nearly 3.5 years after the incident.
Yes.
And I think you talked about the importance of kind of seeing where the person is now, and then also looking at the circumstances of when the event occurred, both being important considerations.
Yes.
And when you evaluated him in the fall of 2023, I think you did state in your report that he did not display any of psychotic symptoms.
When I saw him
Yes.
last year,
Yes.
no.
But that would not be inconsistent with diagnosis of brief psychotic disorder.
That's correct.
And I want to ask you a little bit about the testing that you did. You mentioned some of that in your answering of your questions to the judge. In your report, you indicated that the testing included an MMPI. This is on pages 32 to 33.
Yes, sir.
A PAI.
PAI is called the Personality Assessment Inventory, somewhat of a companion test to the MMPI. The MMPI is the Minnesota Multiphasic Personality Group. PAI and MMPI go together.
And then you also gave a MCMI-4.
Yes.
And can you explain to the jurors what that is?
It's a big name. It's Millon, M-I-L-L-O-N, Clinical Multi-Axial, M-U-L-T-I-A-X-I-A-L, Multi-Axial Inventory. First two invalid, that MCMI test, I like to use it because it helps me understand if there are enduring psychological problems the person had before they're taking this test. Is there a history of poor impulse control, disordered thinking, delusional thinking? But I want to use that third test to help solidify any questions I have.
You did say that basically it was difficult to interpret the results of those tests. Is that correct?
Correct.
That they did not provide you any information one way or the other in terms of diagnosis.
Well, there is some standouts in the MCMI, and I noted in the report, depression, that's understandable. He had an impoverished affect. I mean, he didn't show much emotion when I talked to him, except one time when he was conveying a situation that occurred when he was younger, what he saw. But I did not see, I saw depression for him, but I didn't have enough evidence to say I could clearly diagnose him with something at the current time in terms of any No brief psychosis right now, none.
And on page 33 of your report, you do say there's no evidence of disordered thinking or personality pathology, correct?
Correct.
And in addition to depression, I think you indicated that there were fatigue and sleep problems.
Yes,
Page
33, I believe.
yes. And then also as well as symptoms of PTSD.
Yes, sir.
And PTSD would be post-traumatic stress disorder.
Correct.
But you didn't indicate anywhere in your report that you felt that Mr. Dorsey was not necessarily being cooperative in this testing.
He was cooperative with me. He answered my questions. He was congenial. I thought he put an effort into it, put good effort into it. I can't thoroughly explain the testing other than it was invalid and the way the scores were. I was able to use some limited use with the MCMI, which is why I wrote this.
The depression and fatigue and sleep problems and PTSD symptoms.
Yes, sir.
You did mention that you received reports from several other doctors. Actually, we sent you the other reports of the doctors, including the results of an MRI and PET scan, neuroimaging by Dr. Gurr.
Yes, sir.
And you did say that your diagnosis and conclusion was based upon your review and your opinion was not done in conjunction with any of the doctors. That's fair to say.
Say that again, please.
I'm sorry, it's probably a bad question. Your diagnosis was based upon your judgment and your review. You weren't, it was done independently of the other reports.
Well, it's my opinion. I used information that they gathered as well as I did, but it's independent. It's my opinion.
You did mention in your report that there is some indication that there may be some issues of a defective brain, I think the way you described it.
Yeah, I mentioned that. That was based upon the MRI information I obtained, so the Dr. Gurr's report. Dr. Gurr and Dr. Gold.
Right, Dr. Golden also did neuropsychological testing. And on page 28 of your report, you did acknowledge through information that you received, I think from the defense, of the fact that Mr. Dorsey had suffered from concussions while playing football.
Yes, sir.
That he had problems with concentration, confusion, headache, sensitivity to light as a result of the history of those concussions. This would be page 28, I think the second paragraph.
Yes, sir, I did. I wrote that.
Given the neuroimaging that you viewed of Dr. Gurr, you found Dr. Gurr's neuroimaging consistent with a neurocognitive disorder.
I will let Dr. Gurr's opinion stand. I did not do neuropsychological testing on it, but I did see, it seemed like there was robust evidence from what he wrote for me to include in the report.
If I'm reading your report correctly, and I'm looking at page 32, I'm looking at kind of the first three paragraphs at the top of page 34. You felt that data indicates a neurocognitive disorder confirmed by imaging, which likely could have played a contributing factor to Mr. Dorsey's emotional state and unable to appreciate the wrongness of his behavior.
Very well.
And can you explain to the jurors in a little more detail what you meant by that?
Good. Whenever I review another doctor's reports or data, I look at my own data. see if anything in that data information that would be helpful to me. And I think with his report I did. I simply wrote in the report what his findings were, and it seemed as though as he wrote that there were some substantial neurological problems with his cognitive problems with him. I did not assess him for that. I want to let someone else opine on that.
And how might this have played in relation to Mr. Dorsey's inability to appreciate wrongfulness?
If he has a neurological problem, and I'm going to focus on CTE, concussion injuries. And I've seen this in clinical practice when athletes have come back. When they've been hit hard over a period of time, and it's usually starting in middle school now, football, and then high school, when they've been hit hard, they will have the injury at the beginning, and then they resolve it. But if you have a number of CTEs with concussive injuries, it adds up over a period of time. I had to wonder whether your client was suffering from injuries from a concussion, or long-term injuries, which is why I like to look at what Dr. Dorsey was, showed imaging that he knew how to interpret, but I didn't.
And how might, in your opinion, would that have played? I know your primary diagnosis is brief psychotic disorder, that he was suffering from a delusional belief that his life was in danger at the time of the incident. Did you see the neurocognitive disorder as playing any role in addition to the brief psychotic disorder in your determination as to whether or not you should follow this action?
I see it playing a role, and I'm going to go on the doctor's report, but I could not verify neuropsychological findings. I didn't attempt to do that.
I want to talk to you about marijuana usage.
Yes, sir.
In looking at your report, and if I understood you correctly, you may have modified this since your report, but looking at your report, the second paragraph on page 35, given his marijuana use, he would also meet the diagnostic criteria for cannabis use disorder, which I don't believe significantly contributed to his behavior. Is that still your position today?
I'm a little confused about that. I've had in clinical practice some people with marijuana psychosis, or at least mood changes based on marijuana use. I had not seen your client back in 3 years ago, so I didn't know what effects it might have had on him then. Now he looks okay. But I had to wonder what role that played in it. Now, I'm more likely to say it had to play some role in this situation. I don't think it was exclusive. It did not cause him to do what he did, but it played a role in it.
So your opinion still is it was the psychotic disorder, the delusional beliefs associated with that mental illness on the day of this incident that impacted his ability to appreciate wrongdoings.
I think
Marijuana may have played some role, but the mental health disease, severe mental health disease, is brief psychotic disorder, and that is the primary cause of his inability to appreciate wrongdoings.
I think that's why we're here.
I don't believe I have any further questions.
Any questions from the state?
Yes, Judge, thank you. Afternoon, Dr. Ross.
Sir?
You reviewed some medical records of the defendant that dated all the way back to, I think, 1992. Is that correct?
As Kanazi records?
Yeah. And one of those records that you looked at was a note from August 14th of 2015. And this is on page 23.
Thank you.
Sorry about that.
More welcome. I'm there.
And you noted that in that August 14th, 2015 report, there was no mention of concussions or, is it syncope? Am I saying that right?
Syncope.
Syncope. And that's fainting
Fainting.
or passing out, right?
Yes, sir.
So no concussions documented, no record of fainting or passing out, but you did clarify that it is possible that the defendant wouldn't have told his doctor about these concussions at the time in 2015.
I recall that he would not have told his family or his coaches about that, because that would have pulled him out of football.
Okay.
He kept it hidden.
Sure. So it's not in the records that you reviewed.
What's not in the records again?
No record of concussion.
No, okay, right. In this one, there was no record. That's what I wrote.
Now, two of the tests that you tried to administer were the Minnesota Multi-Phase Personality Inventory and then the Personality Assessment Inventory. Is that right?
Correct.
We heard testimony earlier from Dr. Golden, who administered those two tests in late September, early October 2022. How often in your career do you administer those tests to either a patient or a client or defendant where they've already been administered by another doctor? Is that a common occurrence to sort of double up on the testing?
It does happen.
Okay.
It does.
Now, you mentioned that when you administered them, the results were invalid due to inconsistent responses.
Correct.
Is that common where they're able to complete the test and give responses that are statistically valid in one time, and then later on you go to redo the testing and it's invalid?
It's possible, yes.
Okay. What might cause that?
Well, first off, if you're taking the test the first time, you might get an idea in your head what the test is looking for. I tell patients not to try to read the questions, but you kind of get an idea. And when the second time, you kind of know what's coming your way, I guess.
Okay. So then the second time you try to sort of game it, it will detect that and register invalid results?
So I didn't understand that question.
So I guess if you're saying the first time you might pick up sort of on what the pattern is and what the test is looking for.
Yes.
So then how does that result in an invalid assessment later on?
Well, it could have been, for him, it could have been lack of concentration or attention. There were a lot of questions thrown in at once.
Okay.
But I don't think that would have accounted typically for the invalidity I got. I did not go back and ask the defendant,
Sure.
Would have.
Okay. Just very, very briefly, the marijuana. He told you that he acquired marijuana from multiple states where it's legal, right? That was sort of the way that he procured it.
Did you cite me?
You know what? Sorry, I just made a note of that when you were talking before. That is page 27.
Thank you. I'm there.
So I just want to make sure that's accurate. He tells you that he sources it sort of from other states where it's legal.
Page 24, you said?
27, I'm sorry.
Okay, let me get there first. I like looking at my data. Sources from California, Michigan, and Colorado.
Okay. On the very last page of your report, you sort of go through the delusion that the defendant was experiencing. Then at the very bottom, you say, somehow he was able to appreciate the gravity of his case when he opened the door and found the deceased officer laying there. So my question is, how does that work? That obviously a dead police officer, that's a traumatic sight. How does that impact somebody who's in the throes of a delusion where they see it and then they're able to, as you say, appreciate the gravity of the case?
He knew what he did, meaning he admits that he did that. And it's overwhelming to him to believe that he actually shot the officer. And I listened to the 911 calls, and it was horrendous. But he was in a state of shock when that happened. When he saw her dead, he realized he did it. And that's what he...
Is that because it's a stimulus that's so sort of traumatic and shocking that it kind of recalibrates the mind of the person who's in that delusion?
I don't know about that, but it is a severe shock that he's now left to believe, think, how am I going to handle this? I have a dead person in front of me that I caused the death. I remember talking to him about that too.
I've done it for you.
Further questions for this witness, Mr. Castellano? No. Ladies and gentlemen, you got questions for this witness? I see at least one hand. software-based MRI evaluations? I guess that's a yes or no question.
MRI?
Yeah. Software-based MRI evaluation.
No.
Would you be qualified to comment on an appropriate sample size that would be used in the software? If you're not familiar with the software, you probably can't answer that.
Don't know.
Fair enough. Okay, we'll skip on that. Do you have any theories as to where the PTSD may have come from? And if so, where?
Yes, the defendant's family in my report, and Bianca Davis, I believe, said that he grew up in a drug-infested part of Indianapolis. I don't know you sure that well. I remember his father having said that, or his brother having said that his father had to keep drug dealers off his porch. So it tells me that he was involved in some bad experiences. I think he said to me that he also had some PTSD from watching, as I said, some gang member getting shot or pulled out of a dumpster, something like that. That stuck in his mind, and he became emotional and talked about that with me. So he was exposed to some early experiences that led the way to this.
The jury's heard evidence that the defendant owned a bulletproof vest. Did you ask him about whether he was wearing that during the psychotic episode?
I don't recall he was wearing it during that time.
All right. Do you believe that the bulletproof vest is significant?
Yes, it's his way of defending himself out of fear and out of paranoia. I think some people wear bulletproof vests nowadays, but for him it had a different function. I think it was purely for protection. He thought was going to be harm coming his way.
That completes the juror's questions. Questions on the juror's questions, defense?
No.
Steve?
No, Judge.
Ladies and gentlemen, do you have further questions for this witness? All right, I don't see any hands on that, sir. You may step down. Thank you.
Thank you, Your Honor.
Thank you.
Your Honor, release from subpoena.
Where's Steve?
Yes, Judge.
Yes, Judge.
Okay, thank you. Say yourself back.
Thank you.
All right, ladies and gentlemen, before the court calls the next witness, there's some legal issue that the court has to take care of with the lawyers. This will give me an opportunity to have a longer break. We'll be get back to you. So I don't know how long this recess will be, but again, our goal is to finish everything before 6 o'clock this evening. So if for some reason I don't think that's possible, I'll explain you back and I'll excuse you. But we will try to take care of this legal issue beforehand. So you're not to further express any opinion about the guilt or innocence of the defendant until you've heard all the evidence here. Counsel in the court's final instructions. You may discuss this case amongst yourselves, provided that you're all together in the jury room and you don't go to the ultimate question of guilt or innocence. If anyone does try to talk about this case, you must report that to the court immediately. With that, we'll be in recess.
All rise.
All right, please be seated. Recognize the jury outside the room.
Thank you, sir.
The next witness would be Dr. Amy Trudette. The defense previously filed a motion objecting to her testimony and filed a brief on that. I don't remember off the top of my head which number it was, 98. I know the state did file a written response prior to the court calling her as the court's statutorily required witness. Does the defense wish to make a further record on this issue, and if so, how do you wish to make that record? Do you want to take testimony from her, or how do you want to do that?
I'd like to take testimony.
Okay, all right. I'll go retrieve her. Okay.
All rise.
Unless you just want some exercise. And Josh, what about tell the court the truth, the whole truth, nothing but the truth, and nothing to be perjury? Please have a seat. And for the record, you are,
Dr. Amy Trivet.
and you want to spell it for our court reporter?
Sure. My first name is spelled A-M-Y. My last name is T-R-I-V-E-T-T-E.
And then, defense, do you have questions for Dr. Trivet?
Yes, Judge.
Okay. For purposes of this hearing, can we all agree that we've got her curriculum vitae, which is of course Roman numeral 2, and all parties have had access to the report that she submitted to the court? We all agree on that?
Yes, Judge.
Yes, Judge.
Okay, all right, then, for the record then, Mr. Casanova?
Thank you, Judge. Doctor, is it Trivet?
Yes.
And Dr. Trivet, I would just like to ask you a few questions about your work in this case. You did meet with Mr. Dorsey and pursuant to court order, is that correct?
I did.
And for the purpose of diagnosing whether or not he was suffering from a severe mental illness at the time of the offense, and whether that impacted the ability to appreciate wrongfulness.
Yes, I did.
Based upon your report that you issued, you do believe that Mr. Dorsey was exhibiting psychotic symptoms at the time of the incident.
I do.
And I think specifically you stated in your report that there is no known non-psychotic explanation for his behavior at the time of the incident.
I can't recall exactly how I phrased it, but I think it was something to that effect.
Okay.
I think I might have used the word specifically motive as opposed to explanation.
Well, let me move on. But it's correct that you do not believe that marijuana use alone could account for the psychotic symptoms you experienced on the day of the incident.
Well, that's possible. I think that it's likely that his marijuana was contaminated with another substance.
Correct. So, but if we're talking about it not being laced with another substance, you do not believe that marijuana use alone, unlaced marijuana, would account for the psychotic symptoms he experienced on the day of the incident.
Again, it's possible, but I think it's less likely. Typically, any psychotic effects from marijuana tend to resolve within a brief period of time, and he had symptoms that persisted longer than is typically seen with marijuana alone.
You did give a deposition in this case, correct?
I did.
And I'm going to point you to page 26 of the deposition, and this is lines 20 through 23. Dr. Tripp, if you could just review those to yourself. Lines 20 to 23.
Okay, I did.
So during the deposition, you did say marijuana alone is unlikely to cause the severity of the symptoms that he experienced. I think it's fairly safe to assume that his marijuana was altered in some way,
Yes.
And it's based upon that assumption that it had to be something more than just marijuana, that Kate, you believe that the marijuana was adulterated.
Based on his clinical presentation and the course of his illness, yes, I believe that there was probably something more than just simply marijuana that he consumed into his system prior to the incident.
At one point you did say that this assumption is just a speculation on your part, is that correct?
But the idea that the marijuana has been adulterated with another substance is speculation in the sense that I don't have a lab test to prove that it was adulterated with another substance because he wasn't tested for synthetics, which are very difficult to test for anyway. But I do believe his presentation and the clinical course of his illness is consistent with a substance-induced psychosis. The reason I gave him other unknown substance-induced psychosis is because there's no way to know with certainty what substance exactly caused these symptoms, but I think it's very clear that it was a substance-induced phenomenon.
This is based upon your subsequent clinical evaluation, not based upon any evidence that you received to confirm the presence of synthetic marijuana. Is that correct?
It's correct that I don't have a lab test to confirm the presence of an additional substance, but based on his presentation and my clinical experience with others with similar symptoms and what I know from colleagues and reviewing literature over the years, that this is very consistent with what we typically see with a synthetic substance-induced psychosis. I didn't give him that diagnosis because I can't say that with 100% certainty, but I think it's very clear that he had a substance-induced psychotic episode.
Okay. But you were aware of the toxicology report in this case, correct?
Yes.
And that toxicology report only showed a confirmation for THC, correct?
Yes, and its
And
metabolites.
THC carboxy.
Yes,
It was also negative for the presence of alcohol.
correct.
So any toxicology report that you had the opportunity to review in this case did not confirm the presence of synthetic marijuana.
Right, I believe they were not tested for, and even if they were, again, they're very difficult to test for because the substances used to construct synthetics change all the time, and so it's virtually impossible to keep up with those substances and be able to have accurate testing for them.
Well, you did have the opportunity to review the interrogation of Mr. Dorsey, correct?
Yes,
And during that interrogation, he was specifically asked by the detectives whether or not his marijuana was laced with anything.
that's correct.
And he told them no.
That's correct.
So he did admit to smoking marijuana with the detectives, but denied that it was laced with it. Is that correct?
That's correct.
He did tell detectives in that questioning how much he smoked,
Yes.
where it was in the apartment, correct?
I don't recall if he said specifically, but I think he was pretty open about his use.
Okay. But you had no information that any marijuana was recovered from that apartment.
No, I didn't have an evidence list to know for sure, but I believe you mentioned that it was not recovered.
I guess my point is you did not have, in addition to no information in the toxicology report, you didn't have any information from any testing of the marijuana that was found in the apartment to confirm whether or not it was laced with anything.
No, I did not have any additional testing of the actual marijuana.
And you also reviewed records of Mr. Dorsey when he was at the Marion County Jail, correct?
Yes,
And when he was at the Marion County Jail, again, the only thing he admitted to using was marijuana.
yes, other than, I believe there was one interview where he admitted using K2 and then recanted that shortly afterwards.
Well, that was at RDC.
Okay,
At the Marion County Jail, the only thing he admitted to using was marijuana.
I believe believe throughout the records, that's all he admitted to, other than the one time when he mentioned K2.
So there was this one incident when he was at RDC, I think on April 15th of 2020. It was during an intake interview. Does that sound familiar?
Yes.
And during that intake interview, there was initially a entry about him admitting to smoking K2 on the day he killed the officer. And then within 24 hours or less, he was interviewed again and said that he never smoked K2. Is that
That's correct.
Okay. And you have worked in corrections as a mental health director and provider in corrections, correct?
Yes.
So you are familiar with these type of intake reports, correct?
Yes.
And it certainly is not unusual for there to be errors in intake reports.
Sure.
When you met with Mr. Dorsey as part of the clinical evaluation, he made no admission to you about smoking adulterated marijuana.
That's correct.
You also reviewed reports from Dr. Golden, Dr. Darker, Dr. Parker, and Dr. Calloway. The defense, we provided you with those reports. Is that correct?
Yes.
And there was questioning by those doctors about whether he used, about his marijuana use, correct?
Yes.
And in none of those reports did he admit to those doctors that he used synthetic marijuana.
That's correct. I'm not sure that he knew that he was using something in addition to just marijuana.
Okay. But just in terms of actual evidence, in terms of a toxicology report, in terms of admissions to doctors, admissions to you, or admissions to the police, there's no evidence of him using synthetic laced marijuana.
Well, the evidence is in his clinical presentation and of course of his illness. Typically, again, the psychotic effects of marijuana, if someone experiences those, tend to resolve within 24 or 48 hours versus what we see with synthetics that persist for days, weeks, sometimes months, and sometimes even longer, even with treatment. So his presentation was more consistent with that than it would be with just simple marijuana-induced psychosis.
So,
Again, I can't say with 100% certainty, and that's why I gave him the diagnosis of other or unknown substance-induced psychosis, but his presentation was certainly more consistent with a synthetic-induced psychosis than a marijuana-induced psychosis.
I understand the clinical presentation, but I'm just talking about evidence other than the clinical presentation. There is no evidence other than what you are interpreting in the clinical presentation that he used synthetic marijuana that day.
Other than his clinical presentation, no. There's no lab test, and he didn't report having used synthetics.
Now, Mr. Dorsey, from your review of the material, had been exhibiting psychotic symptoms for up to a month prior to incident.
Yes.
And you stated that, as we pointed out in the deposition, that you don't believe that marijuana alone, unlaced marijuana, would account for those psychotic symptoms.
That's correct.
Especially if the person had never experienced any prior adverse effects from using unlaced marijuana.
That's hard to say. When people are using illicit substances, everyone responds differently. Sometimes there are cumulative effects such that, somebody has a different response if they've been using daily for years versus somebody who just uses once. It's a little bit hard to predict, so I can't exactly say if that's accurate or not.
Well, certainly you would agree that if somebody had mentioned that marijuana use makes me paranoid, I've experienced severe paranoia in using marijuana, that then that person may be more likely to experience symptoms of paranoia from use of marijuana alone, as opposed to a person who says, I've never had that experience, I just use it because it relaxes me.
That's probably true. People who have experienced those symptoms before tend to experience them again, but that's, again, a different kind of psychosis than what we typically see with synthetic-induced psychosis. That's that, mild paranoia that people tend to be more aware of and tends to resolve within a day or two as opposed to persisting for weeks and months.
And I understand that point, but I'm just talking about somebody who is using marijuana and marijuana alone. If they,
Mr. Castaneda, I think we're well past gatekeeper issue. I think this is cross. I don't think this is gatekeeper issue.
I'm not sure I understand.
I think I've heard enough to make my rulings, I guess is what I'm saying. And rather than elongate this, I'll allow you to instead of going through question and answer, I'll allow you to make your record just simply by making your argument or citing what you wish to do.
Well, I mean, there is some additional question regarding the clinical evaluation.
I understand, but there's a difference between you disagree with her assessment versus whether she has the expertise or qualifications to make the assessment. That's the only thing that we're dealing with now. I serve as a gatekeeper, not a weigher of evidence. And I think what you're asking me is to do at this point with these questions is to weigh it.
Judge, I would disagree. I think the cases that we cited specifically state that there is no gatekeeping function if the opinion is based solely on speculation.
Except for it's not based on speculation, because I'm reviewing gatekeeper function. She's allowing the Rule 704 to rely on information contained outside the record, even if it's inadmissible. In Miller on evidence, that Miller talks about the use of polygraph exams. A witness is capable of making a determination if it's the type of information that is based upon by experts or people within her field. The evidence shows that the defendant allegedly made, and I understand that's a matter of dispute, but as far as a gatekeeper function, the defendant made a statement that he used K2. That is sufficient enough. That is a hearsay exception. It's reliable on the record, unlike a polygraph exam, which is inadmissible. Under 704, she's allowed to make that opinion. Under 702, the only thing that gets excluded from a gatekeeper is if it's based upon, if we're talking about a scientific principle. I don't see a scientific principle here as a gatekeeper. She's talking about the effect of a drug unknown on a human body. By definition, she doesn't have, there isn't a test on it. So we're not debating the accuracy of an instrument that measured a drug. We're talking about the effect. I understand your argument, but that's all your cross-examination as it goes to the weight of her report, not its admissibility.
Well, yes, Judge, our position is that whatever is in the record is the equivalent of a prior inconsistent statement. If it was made, it was correct. It is not substantive evidence. There is no substantive evidence.
A defendant's admission of drug use, how is that a prior inconsistent statement as opposed to substantive evidence?
There is the statement and then there's the contradiction.
Well, and I understand that, but she can base her opinion solely upon the statement itself. That is substantive evidence as far as she's concerned for making the basis of her opinion.
Well, I guess beyond that, Judge, our position is that there is no evidence to support her conclusion that this is based in him smoking synthetic laced marijuana. There is no toxicology report. There are no admissions. She even admitted that marijuana alone.
When you say no admissions, what do you mean? You have a defendant statement in RDC. That's an admission.
Well, it's an admission that also includes an immediate contradiction.
Within 24 hours, not 2 seconds.
Well, it's the next time he's interviewed.
I understand. All of that goes to weight, not admissibility.
Well,
I'm willing for you to make the record, but I don't see, I mean, I've heard the foundation, I've read the cases you've cited, I've read Miller on that. I think it's a weight and not an admissibility issue. So in the interest of time, I'm willing to let you go ahead and supplement the record without the question and answer format, and just simply put in your offer to prove. If there's additional, I mean, you've already briefed the issue, but if you want to supplement that brief with additional offer to prove, I'm giving you an opportunity to do it as quickly as possible, as opposed to the question and answer format, because I'm satisfied based upon my research. I've read a report, what it's based on. I think it is a weight issue and not an admissibility issue. And that's what you're asking me to keep it out totally, is admissibility. And I don't see under the law that under the rules of evidence that would be the proper rule. But I do understand your argument. So do you wish to supplement? The mic is yours.
well, what I would supplement the argument with, Judge, is first of all, you've seen the case law, those cases in which those experts opined on information that was not in the record and was based on total speculation. The courts did find that that is prior to, I mean, in order for there to something for the jury to consider in terms of cross-examination, there has to be some basis for the opinion other than speculation. Our position is that there is no evidence of this marijuana being laced. The only evidence, our position, is the one RDC record that is an intake record, which he is confronted with having allegedly made the statement, which he immediately denies having made. And other than that, he never admitted to smoking laced marijuana. Essentially, from our perspective, that is an inconsistent statement. It would be a prior inconsistent statement for impeachment purposes. It is not a sworn statement. In those cases, a prior inconsistent statement, if you impeach somebody using an unsworn statement, that is not substantive evidence. It simply goes to credibility. Other than that, which is not substantive evidence, there is no basis for her to form this opinion.
I just think we disagree on the definitive statement about criminal conduct not being substantive evidence. I think it clearly is. It's a clear hearsay exception within the rules. I don't think it's within the doctrine of inconsistent statement at all.
Well, given how it was made and the circumstances under which it was denied, and we would argue that it is a prior inconsistent statement. Beyond that, in terms of clinical presentation, I think Dr. Trivett's testimony would be that because the psychotic symptoms disappear without treatment, for the most part, because they disappeared without treatment, that is evidence to her based upon her prior experience that this was a substance-induced psychosis rather than severe mental illness under Indiana statute. But that does not account for brief psychotic disorder, which by its very definition disappears without treatment. So in terms of that clinical presentation, and also in terms of any statements that Dr. Trivett would make regarding her knowledge of how drug dealers lace quantities of marijuana and then deal those larger laced quantities of marijuana in smaller packages, again, would be beyond her expertise to testify about. So for that basis, Judge, we would argue that Dr. Trivett's testimony regarding Dorsey's smoking synthetic waste marijuana is based solely in speculation. And as that, it got to go to the jury because there has to be some basis for
Okay, any further record you wish to make?
that is all.
All right. The court will show that the defendant's 98 court denies the request to exclude. I think based on the colloquy here between myself and defense counsel, I do believe that the record is such that, first off, I don't think there's no one's challenging her educational background and her ability to, her expertise and background in this area in general in terms of forensic psychiatry. I understand the challenge that she doesn't have an adequate basis on which to make her opinion. The court simply disagrees that an admission by a defendant, which is substantive evidence of the rules, clear hearsay exception, which goes beyond above Miller's description of things can be relied upon under Section 704. That the admission from the defendant that he used K2, she's allowed to make an opinion based upon that as a gatekeeper function. The court believes everything that the defense is raising is subject for cross-examination. It's clearly allowed to contest it, but not in a matter of exclusion. With that, we're ready to bring in the jurors and start the testimony.
I apologize, could I just add one further?
Sure, absolutely.
I think it's our position also that we want to point out, with regard to the record and the statement in the record, we would also add that in our opinion, it is hearsay with hearsay. It is a report of a healthcare provider regarding something Mr. Dorsey said to them placed in the record. So we would also add that with regard to that statement, it is hearsay with hearsay, and as such is an improper basis for the court to consider it as being some basis that it would allow Dr. Trivet to go forward and testify.
All right. Again, the court will cite all of the discussion from Miller on evidence under Section 704. Even if something is considered to be inadmissible, Miller talks about polygraph exams as being one of those reasons that if it's relied upon by individuals informing opinions or giving as a matter of forming an opinion, that the expert is allowed to do that. In this case, I understand that you're saying it's hearsay within hearsay, but it's still the type of evidence that courts rely upon in terms of being admissible evidence, let alone the expert herself in terms of forming. So, with that, unless there's anything else to add to the offer of proof, I'll allow you to supplement the offer of proof if you wish after the end of the testimony today or tomorrow if you wish, because you clearly have briefed the issue and we've talked about those sections of Miller and all, but if you wish to supplement the record further, you may. Other than that, simply from a gatekeeper function, she's entitled to the rules of evidence. So we're ready for the jurors. State, you ready? Defense ready?
Yes,
State?
Are we gonna start now, or could we roll it into tomorrow and just do it?
No,
That was
it's 5:09. She's here from Kentucky. She needs to get back to, she will be here overnight, but she needs to get as much as she she has family obligations to return to tomorrow. So I want to get her in. We're going to go to at least 6. Okay?
All right.
All right, ladies and gentlemen, please be seated. Before we took recess, the lawyers tonight, we were still in the court's presentation. Statutory requirement of presenting evidence on the issue of insanity. The court's doctors, and I have the next witness on the stand, ma'am, could raise your hand. Your comments are about to tell the jurors the truth, the whole truth, nothing but the truth, and the penalty of perjury.
I do.
All right. Can you please tell the jurors who you are and how you spell your name?
Sure. My name is Dr. Amy Trivet. My first name is spelled A-M-Y. My last name is T-R-I-V-E-T-T-E.
And Dr. Trivet, what's your occupation?
I'm a general and forensic psychiatrist.
And jurors have already heard the background for a forensic psychiatrist. And so what's your educational background in that particular area?
I attended college at Duke University and then medical school at the University of North Carolina at Chapel Hill. Then I completed a 4-year residency program in general psychiatry and a 1-year fellowship program in forensic psychiatry. Both of those were completed at UNC Chapel Hill as well. I worked in the North Carolina Department of Corrections for 2 years at a maximum security prison treating men who were housed there for various reasons. After that, I moved to Kentucky and worked at the state forensic hospital there called Kentucky Correctional Psychiatric Center. I worked there for 13 years, initially as an attending psychiatrist and moving up to be medical director for several years prior to leaving that position. During that time, all of my work was pretty much forensic evaluations other than my administrative responsibilities. So I evaluated many men and women charged with felony charges in Kentucky throughout that period of time. About 3 years ago, I left that position and I'm now the director of psychiatric services for the Kentucky Department of Corrections. So basically I help cover all 14 facilities we have around the state, supervise the psychiatric providers that we have there, which is a variety of nurse practitioners and other psychiatrists, and then help cover some of the more complex cases and some of the patients that people are having more difficulty managing as far as diagnosing and treating and that sort of thing.
And do you have any specialized internships or fellowships as part of your background?
Yes, I completed a 1-year fellowship in forensic psychiatry. I'm licensed to practice medicine in Kentucky, Indiana, North Carolina, South Carolina, and Tennessee, and I'm board certified by the American Board of Psychiatry and Neurology in both general and forensic psychiatry.
You also teach in this area?
I do adjunct faculty at University of Louisville, and so I help teach some of the medical students that rotate with me clinically, and I also do some didactics with the psychiatry residents. They have a forensic seminar series in the spring every year. We're in the middle of that now. And so help teach them about some of the forensic topics that come up in general practice and then some of the more specialized topics that come up in my field.
And do you have any professional affiliations?
Yes, I'm a member of the American Psychiatric Association, the Kentucky Psychiatric Association, American Academy of Community Psychiatrists, and also the American Academy of Psychiatry and the Law, which is sort of the governing body for forensic psychiatrists specifically.
Do you have any research or teaching background?
As far as research goes, I haven't done a lot of research since my residency. At that time, it was primarily in the realm of substance abuse treatment, that is sort of the precursor to some of the MAP treatment that you see in the community now. And then as far as teaching goes, just the activities at University of Louisville. There was a time when I also had some nurse practitioner students and PA students as well when I was at PCPC, but I don't do that any longer.
And have you published or any opinions or background information about in your field of expertise?
No, I haven't.
Okay. Have you received any honors or awards in your field?
I think some years ago, I might have gotten the Community Psychiatry Award, but I don't really recall the details. I would have to reference my CV to say specifically. It's been a little while.
All right, on the subject of your CV, let me show you what you marked as Courts Exhibit Roman numeral 2. I ask if you can identify that document,
Yes, this is my CV.
and the court would place that into evidence. Any objection from the defense?
No, Judge.
State?
No, Judge.
All right, so we'll show Courts Roman numeral 2 admitted without objection. During the course of your background in forensic psychiatry, have you had the opportunity to examine individuals to determine the competency to stand trial and whether or not they were sane or insane at a time of an alleged offense?
I have. That's been the bulk of my career while I was at PCPC. I've sort of lost count after about 3,000 evaluations. So I've evaluated many people in Kentucky and also for the federal government at times. And I've done a handful or maybe a dozen or so cases in Indiana.
And specifically on the issue of insanity, you mentioned 3,000. Would that include in evaluations on the issue of insanity?
It would, in Kentucky, we would often be ordered to evaluate both competency and sanity at the same time. And I would say probably, 2/3 or so of that 3,000 cases, we would be asked to do both evaluations.
Okay. And have you testified as expert in the field of forensic psychiatry in this particular area?
Yes, I have. Many times in Kentucky, I would guesstimate, I probably testified about 1/3 of the cases that I evaluated, so probably in the neighborhood of 1,000 times. I've also testified in the federal system and then in the state of Indiana as well.
Okay. And how many times within the state of Indiana? Approximately.
I've probably only done maybe a dozen or so cases in Indiana, so maybe just a few. Most of those have been via phone, so it's hard to recall, but just a few in Indiana.
All right. And are you specifically familiar with the Indiana definition as it relates to insanity?
I am. That's one thing that we learn about in the practice of forensic psychiatry is to, find out what the relevant laws are in the jurisdiction where you're seeing someone face, especially insanity statutes vary from state to state. You may have heard about that from other experts, but there's some variability in the language from state to state, so it's important to know what the actual language is in the state where you're evaluating someone.
When did you first become involved in the case that you're here to testify?
I believe it was last year.
Okay. And have you had an opportunity, pursuant to the court's request, to conduct an examination of Mr. Dorsey on the issue of insanity?
I have.
And under what conditions and for how long?
So I was asked to evaluate him specifically regarding the insanity statute in Indiana. And so I traveled to the facility where he was housed and spent a little over 2 hours with him, in addition to reviewing a voluminous amount of records from things like some of the police reports, witness statements, watching the video interview with the police after arrest, reviewing the reports from other experts, the testing that was performed by other experts, along with all of the medical records from the facilities where he's been housed from the time of arrest up until when I saw him last year.
Prior to examining the defendant, did you obtain any background materials or source information related to this case?
I did. I actually had a meeting with defense counsel via phone, and they sort of laid out what happened, and they sent me a large amount of information to help me understand what was going on, also the medical records, statements from family members, and other information that they had obtained through their investigations.
Did you have an opportunity to review witness statements as they were taken from the Indianapolis Police Department as it related to this incident?
I did. I had statements from some of the victim of the case, from some of the police officers, along with the video of his interview after arrest.
And can you explain to the jurors when you're asked to make a determination on insanity in a particular case, what's the methodology that you use?
So the first step is just performing a standard, thorough psychiatric assessment to help determine, firstly, is there evidence of a mental disease currently or at the time of the alleged crime? So That involves just taking a thorough history from the person and gathering as much collateral data as you can, whether that's information from family members or medical records, or if you have videos and things like that that can give you a picture of what somebody was like at a particular time, that can be really helpful. Then, of course, when you're looking at specifics of an alleged crime, trying to get as much information as you can about that alleged crime, from witness statements to what the individual said about what they were doing at the time, to any sort of objective data that you can get about these things. So that's sort of the methodology, and then you're trying to do your best to sort of reconstruct what their mental state was at that time. And that's difficult to do, because even if you assess them at that pinpoint time of when they committed a crime, which of course no one can ever do, we can't crawl inside somebody's head and know exactly what they're thinking. So we're doing our best to try to reconstruct what were they thinking and what was going on at that time. Based on their reports and whatever objective data we can get speaks to what kinds of behaviors they had at the time, and what other people observed and heard and saw and reported at the time. So those were the kinds of things that I tried to do in this case as well.
And did you do any testing on the defendant when you met with him?
I conducted our routine psychiatric mental status examination. I'm not a psychologist, so I didn't administer psychological testing. He had had psychological testing performed by some of the other experts in my case, which I did review, and certainly incorporated their findings into consideration as I formed my own opinions.
And did you also receive from defense counsel or any other source of reports or conclusions based by other doctors on the issue of sanity as it relates to the defendant?
I did. I had reports from 4 other experts who evaluated him.
All right. And when in your field, when you're making the determination, does that at all affect how the result that you come up with?
Well, I certainly consider that information, because typically those experts have asked a lot of the same questions that I'm asking. So I'm sort of looking to see if they get the same story that I got, if they get different information. The psychologist saw them and did testing that I might not do. I'm going to see what those results were. So I incorporate the findings into my assessment, my opinions, but it doesn't necessarily dictate the conclusions that I make.
And then how much time total do you think you spent actually working with the defendant or interviewing him as it relates to this case?
I was with him face to face for a little over 2 hours.
Okay. And how much time did you spend actually working on the case, reviewing the background material and information?
It was several hours. I don't know. I would have to guess. I'm thinking maybe 20 or 30 hours reviewing all of the records and videos and things like that.
Based upon your work on this case and conducting your examination of the defendant, did you have an opportunity to form or express an opinion as to the defendant's sanity as defined by Indiana law at the time that this offense occurred?
Yes, I did.
And what is that opinion?
So it's my opinion that while he was suffering from a mental disease or defect at the time of the alleged crime, I don't believe that it was to the level of impairing his ability to appreciate the wrongfulness of his actions on that day.
And what's the basis for your opinion?
So the basis for my opinion, as far as the mental disease or defect, I think you've heard from the other experts, and I think everyone's in agreement that Mr. Dorsey was suffering from psychotic symptoms at the time that this happened, and that led to him having some paranoid delusions. There's also mention in the records of possible hallucinations. At other times he denied hallucinations, sometimes he endorsed them, but I believe some of the other staff had observed evidence of him experiencing hallucinations. So I think it's the consensus of everyone that he was experiencing psychosis at the time. So then the next question is, does that rise to the level of making him unable to appreciate the wrongfulness of his actions? As you can imagine, there are psychotic people walking around in the world all the time, but they're still able to engage in some rational behaviors, they're able to make decisions, they're able to know right from wrong and not go around committing crimes all the time, right? So, that's where we are in this case, is trying to figure out, did his symptoms, were they severe enough that it kept him from being able to understand that the behaviors he engaged in were wrongful? And so the things that I look at with that is, the behaviors leading up to what happened, what actually happened, and what his behaviors were, around that time in question. It's clear that his psychotic symptoms seem to be worsening in the days leading up to this situation. I think multiple witnesses described him looking more distressed and being more paranoid and repeatedly telling people that he thought someone was out to kill him. But, for me, where I had some pause about whether he was able to appreciate wrongfulness was, so if he was scared that people were coming to kill him, why didn't he leave the scene? He says he tried to call the police a couple times, and there are some 911 calls, which hopefully you guys were able to hear, where he's reporting to the police that someone's trying to kill him. But he's not, attempting to leave the scene. He's not continuing to, call in these distress calls. He stays with the woman that he thinks is, for this conspiracy to kill him. So, firstly, that makes me, help gauge the severity of the level of his paranoia. How fearful was he of her? At one point, he says that she pointed a gun at him, but he went and took the gun away from her, which again implies, what's your level of fear here of this woman? Do you think she's really trying to kill you or have you killed? So, then there comes this knock at the door that by all accounts was sort of a simple knock at the door, not some, loud, threatening knock, that leads to shooting. And, I think that if his level of paranoia was severe enough that he would not be able to appreciate wrongfulness, he likely would have turned and shot her immediately too. And, immediately afterwards, instead of, knowing it's the police and getting down on his hands and knees and saying, please don't kill me, and, didn't mean to do it. He's not sort of arguing that these people at the door were really there to kill him and maybe impersonating police officers. Those are the kinds of things that I would expect from somebody who truly was unable to appreciate the wrongfulness of what they were doing, that they would persist in these delusions that the people at the door were there to kill him, even if they were in uniform. But he immediately is able to recognize that they're in uniforms, that they're police officers, and that he should not have shot at them through the door. So he engages in some odd behaviors that day, absolutely, but also some rational, goal-directed behaviors that day. So it's not as though he was so floridly psychotic and disorganized that he was unable to appreciate anything that was going on. And so, in my opinion, his paranoia didn't rise to the level of preventing him from being able to appreciate the wrongfulness of his activities. And that's part of the reason why he immediately gets on the phone and says, I wasn't trying to kill her. He gets down on his hands and knees and realizes that the police are coming to arrest him, and he's worried that they might shoot him because he shot one of them, and those kinds of things. And so to extrapolate from that to where he was at the moment that he pulled the trigger, there's no reason to believe that his mental state would have substantially changed in the few seconds to a minute between when he shot and when the door was open.
Does your opinion on sanity, does it change at all from when you're considering the first shooting in which Officer Leath was killed versus the subsequent shooting or firing towards Elliahs Brown in this case?
So that's a good question. I think that if anything, I sort of feel more firmly that he, knew what he was doing. He was sort of pursuing her and shooting at her, as opposed to, there's no way she could be directly threatening him when she's running away from him. And so, if it's hard to understand how a paranoid delusion would make him want to pursue someone and shoot them as they're running just years away from him.
And so, is there any other conclusion that you draw here based upon your evaluation of the defendant and your evaluation of the information you've received as to why this incident occurred?
Ultimately the decision is for the finder of fact, for you guys to decide, whether he meets the legal criteria for insanity in Indiana or not. In my opinion, he does doesn't. I do believe he was suffering from a mental disease at that time that has since largely resolved. But I don't believe that he was able to appreciate the wrongfulness of his actions that day.
Do you have questions on the court's questions?
Yes, Judge. So, Dr. Tribbett, you mentioned that one of the reasons you think that Mr. Dorsey appreciated the wrongfulness of his actions is because he did not do that. Is that correct?
I believe that that's a reflection of his level of paranoia not being severe enough for him to feel the need to flee the scene.
But you did have information that the reason he didn't want to leave the apartment is because he felt he would be killed if he did.
I believe what he told me was that he was looking for his keys and his wallet and he couldn't find them, as opposed to being fearful of being killed. He told me that he felt if he left the apartment, he could have returned to his own apartment and contacted the authorities to report what was going on.
You also stated that you felt that it would be more likely he didn't appreciate it would be more likely that he would appreciate the wrongfulness of his actions, that, if I'm understanding you correctly, in your mind, you would have shot Aisha in the apartment. Is that correct?
That would have been something that would have weighed more in the direction of me feeling that he was unable to appreciate the wrongfulness.
Okay, so you're saying that if, instead of shooting through the door, if he had turned and shot and killed Aisha, in your mind, that would be an indication to you that he did not appreciate the wrongfulness of his actions.
Yes, because it would reflect to me that his paranoia was such that he, truly felt threatened right there that minute. And, she was the one instigating all of this. And so, in order for it to stop, that you have to be.
Okay. Now, you do know that he shot through that door, and before shooting through that door, he said, "That ain't the police," correct?
Yes, I believe both she and he said that.
So that is an indication that he was believing that the person on the other side of that door was somebody trying to kill him. Is that correct?
That's what he reported, yes.
So there are some reports from him that he made to you that indicates that if he did leave that apartment, his life would be in danger.
He didn't report to me or anyone else that I know of that he thought anybody was sort of lurking around outside waiting for him to come out. That's not anything he ever reported to me. He reported that, she made this phone call and then pretty soon afterward heard the knock on the door and there was a big lag of time, other than a few minutes is what he told me.
Well, you did mention the 911 calls, correct?
Yes.
And I think if I heard you correctly, you did say that they are an important piece of the evidence that you consider.
Yes.
And in that first 911 call that you heard that was made by Aisha, he took the phone from her and the first thing he said was, "Bro, you ain't even the police," correct?
Yes.
And then he also said, "I just feel like somebody's been trying to kill me all day."
Yes.
So he did express in that 911 call, which occurred at or near the time of the incident, that he was concerned for his safety, correct?
Yes, and that speaks to the mental disease at the time of the incident.
But additionally, his actions not long after that involved him believing that the people or the threat to him is on the other side of the door. Is that correct?
Yes, that he reported.
Because that's why he shot through the door.
Yes.
So there was a belief on his part at the time of the incident that the people on the other side of that door, outside that apartment, were a danger.
Yes. What he told me was that he thought that perhaps he had come to either kill him or rob him because he typically carried large amounts of money.
So, and you would agree that the critical time in determining whether or not somebody appreciated the wrongfulness of their actions is at the time of the offense, correct?
Yes,
That is what the Indiana statute says. It's ability to appreciate at the time of the offense, correct?
that's correct.
And at the time of the offense, based upon the 911 call, the information from Aisha in terms that you reviewed in terms of her deposition, he believed that somebody was immediate person on the other side of that door was an immediate threat to him.
I believe he felt threatened by them, yes. And this is where, it's up to you guys as the finder of fact to determine was the perceived threat that he was experiencing at that time sufficient to justify the actions that he took and, thereby render him incapable of appreciating the wrongfulness of that behavior. In my opinion, it was not, but, there's varying degrees of paranoia, and I think there's not a question that he was experiencing paranoid delusions at the time. It's just not my opinion that they rose to the level of preventing him from being able to appreciate the wrongfulness.
I understand that, but I think one of the reasons you gave to the jury in responding to the judge's question as to why you do not, or why you feel he did appreciate the wrongfulness of his actions, is because he did not leave the apartment. That's one of the things you just said.
Yes, and I'm meeting for the 4 hours or so earlier in the day that Ms. Brown reports that he was starting to act weird and say these paranoid things. So those several hours that he had prior to the incident occurring.
Well, in addition to those two 911 calls, the defense, we sent you the 911 call that was made by his aunt and uncle, right?
Yes,
And I'm assuming you listened to that 911 call.
I did.
And in that 911 call, the aunt and uncle report that nephew just called me. He's reporting, wanting us to call the police because somebody is trying to kill him.
That's correct. Yes.
And the timing of that was shortly before, not long before the actual incident occurred, right?
Yes, I believe all the phone calls happened within a few hours prior to the incident, but I don't remember the specific times.
So, at that time, when he's in that apartment, based upon the first 911 call and the 911 call that he made to his uncle, aunt and uncle, he is expressing that his life is in danger. Somebody is trying to kill him, right?
That's correct.
To the point where he's asking a relative to call the police for him.
That's correct. Again, I think that speaks to the mental disease and the paranoid delusions he was experiencing that day.
And it's not long after that he does shoot through the door, correct?
I don't recall the specific times of the phone calls, but I know they were within a few hours at least.
Well, certainly it's in a tight time frame regarding these 911 calls and the shooting through the door. We agree to that.
I guess it depends on how you characterize tight, but yes, within a few hours of the incident.
And we've already established that when he shot through the door, he believed that threat was on the other side of that door.
Yes.
Okay.
Although he, had also reported to everyone that he thought Ms. Brown was the one sort of orchestrating all this. So, there was a perceived threat on this side of the door as well.
Right. But clearly, in his psychotic state of mind, his delusional state of mind, he saw a threat from Ms. Brown, as you just stated, right?
Yes.
And he also saw a threat on the other side of that door based upon his actions of shooting.
Yes, and his report, yes.
So there is evidence, certainly, to suggest that his delusional state of mind believed that not only was there a threat in the apartment, but a threat outside the apartment.
Yes.
And you just mentioned that he also talked about believing that Aisha Brown was part of that threat.
Yes.
Now he did shoot her after she went out that door, correct?
Yes.
You read the deposition of Aisha Brown.
I did.
And in the deposition of Aisha Brown, she stated that after he shot her, he came up to her, made a comment to her as if she was conspiring to have him killed, took her phone and went back to the apartment.
Yes, that's correct.
Certainly that is consistent with the earlier belief, or a continuing belief, that Aisha Brown was part of who was involved in trying to have him killed.
Yes, and I believe he's persisted in having those thoughts and questions for quite some time after the incident.
And in shooting Aisha Brown, that comment is consistent with the delusional belief that she was trying to set him up to be killed.
I'm sorry, can you repeat
Well,
that?
the comment he made that is in Aisha Brown's deposition, that he made a comment to me after he shot me as if I was conspiring to have him killed.
Yes, that's correct.
So we're talking in the immediate time of the event. At the time of the event, he's believing that there was a threat inside the apartment from Aisha Brown, correct?
Yes,
And a threat outside the apartment because he fights through the door.
yes,
And in the immediate time frame after that, when he shoots Aisha Brown as she's running out, he comes to her and identifies, according to Aisha Brown, that she is a threat because she's conspiring to have him killed.
yes, that's correct.
And he takes her phone.
Yes,
Wouldn't be able to call anybody without that phone, right?
right. I believe she was already on the phone with 911.
911.
Yes.
Right. So there is evidence at the immediate time the incident occurred, both the shooting of the officer and the shooting of Aisha Brown, that he had a delusional belief that his life was in danger, not only from Aisha Brown, but anyone outside the apartment.
Yes, and that's why it's my opinion that he was suffering from mental disease at the time.
I don't think I have any further questions, Judge.
State, do you have questions for her?
I do, Judge. Dr. Truitt, I want to start by pointing out it sounds like you have an excellent academic and professional pedigree. Duke, UNC, now you supervise all of the well-being, is it the name of the organization in the Kentucky DOC?
WellPath.
WellPath, I'm sorry. That's interesting because earlier today we heard some testimony from some other doctors that generally the quality, the training, the education, the professionalism of the people who provide psychological and psychiatric care in DOC is usually subpar. So you don't agree with that contention, right?
I don't know, and I think that is the case some places and not the case others.
Sure.
I have not worked in the Indiana Department of Corrections, so I'm not qualified to comment on the care here. But I would say that the care patients received in North Carolina where I worked was excellent, although I had understood years previous to that it had not been the best, but it was excellent when I was there, and I believe Kentucky care is very good these days too.
Sure. So I guess, why don't we get to it? What diagnosis did you make for the defendant?
So the diagnoses I gave him were other unknown substance-induced psychotic disorder, a cannabis use disorder, and an unspecified anxiety disorder.
Now, what was it that led you to your diagnosis of other unknown substance-induced psychotic disorder?
Well, the clinical presentation of Mr. Dorsey is inconsistent with a severe persistent mental illness in that his symptoms resolve without any sort of treatment. So if someone has schizophrenia or a chronic psychotic illness, really the only way that they get better is through medication. He was never medicated and his symptoms resolved gradually on their own. As far as using the other or unknown substance, that's because it's hard to say exactly what substance it was that caused these symptoms. He has admitted using marijuana regularly. He admitted that to me and has admitted that to others. There are other reports in the record from other witnesses and the medical records that mention other substances, and then at other times he denies using other substances. What my experience has been, and what the literature discusses, and what colleagues have observed, is that people who have more of a marijuana-induced psychotic disorder, those are the people who say, oh, pot makes me paranoid, and then, tomorrow they're fine. That's the kind of psychosis that people tend to experience with marijuana, if they experience any psychosis at all. They might get a little bit paranoid, and then it resolves pretty quickly. But what we do see sometimes sometimes is that sometimes marijuana can be adulterated with other substances, often unbeknownst to the user. And sometimes those substances are more these synthetics, like spice that you've probably heard of people using in the community. And sometimes those can cause more persisting psychotic symptoms that can last days, weeks, sometimes months, even years, and sometimes require treatment, sometimes resolve on their own. In reviewing Mr. Dorsey's records, it appears that he continued to have psychotic symptoms for at least a few, pretty significant symptoms for at least a few weeks that were gradually resolving, but he was continuing to have delusions, significant paranoia, some reports of hallucinations, and then even beyond that, he continued having some residual paranoia, which is generally inconsistent with what we most of the time see with marijuana. So I suspect there could have been other substances that adulterated his marijuana. I can't say with certainty that that happened, but I think his presentation is consistent with a substance-induced psychotic disorder because it resolved without treatment, and just his presentation, some of the symptoms he exhibited are consistent with what we see with people who have substance-induced psychotic disorders.
And doctor, in your experience, can somebody ingest adulterated or synthetic marijuana without even realizing it, with still believing that they're using regular marijuana?
Absolutely. I've seen many patients come in who have, long-term marijuana users who smoked for 30 years, never had a problem with it, and then, just had a floridly psychotic episode and committed a crime, no criminal history, just completely out of character behaviors. And unfortunately, that sort of thing is happening more and more commonly, and we're seeing more and more of that in the settings where I work.
Now, you reviewed a toxicology result that was an analysis of the blood withdrawal from the defendant, right?
I do.
And it was positive just for marijuana.
That's correct.
What knowledge about the detection of synthetic marijuana or adulterated marijuana in toxicology tests do you have?
Judge, I'm going to object to this as beyond the scope of the expertise in this witness.
All right. We'll the objection. You want to show it as a continuing objection in this line?
Yes.
All right, you may.
So we have, in our field, tried to develop better testing for synthetic substances, but it's almost impossible to do that because the substances that are used to construct these synthetics change all the time. So as soon as a test is developed, then it's irrelevant because people have moved on to using different substances to make synthetics. So we do a very poor job in the medical field of being able to test for synthetics, and so most of the time it's not even tested for, as is the case in this situation.
And then with regards to any marijuana that was tested itself, you're not aware of any marijuana that's collected at the crime scene for analysis, correct?
I'm not.
So your basis for your diagnosis of other substance-induced psychosis, it's based on the defendant's clinical presentation. What he explains to you about his prior drug use, what he explains to you about his feelings that day, and then his pattern of behavior after the fact.
So other or unknown means I don't know which substance caused the episode. Could it be marijuana? Possibly, but it's less likely. It's just not what we typically see as far as the clinical presentation and the clinical course that we see with that substance. Could it have been something that the marijuana was adulterated with? Absolutely, and that's sort of more consistent with what I've seen clinically and what's described in the literature and what colleagues have seen. Could it be one of the substances that he endorsed using at one point, or a witness reported that he was using at one point, but then was denied at other times? Possibly. So I don't know which substance it was with certainty, but yeah, I do believe it was a substance-induced episode.
Sure. Now, you mentioned a minute ago statements that were made to some other people. Specifically, are you aware of a statement from April 15th at RDC intake where the defendant admits to smoking K2?
I am.
Now, for the jury, what is K2?
So it's, as I understand it, it's another reference to spice, which is a synthetic marijuana.
Sure. Now, to be clear, the next day he went back on that assertion, right? Said, no, I didn't smoke K2.
That's correct.
But did his initial admission that he smoked K2 play into your diagnosis of the adulterated marijuana being the cause of psychosis?
Yes, I mean, it's not sort of the most significant factor. It's really the more significant factor is his clinical course. But that, throws out there another possibility of what the causative agent was.
Sure, because you're not just going to take him at his word, you're going to look and see how his statements integrate with his entire clinical presentation and the facts that you see in all of the collateral sources, right?
Yes.
One moment, Judge. And I'm sorry, I should clarify. That statement on April 15th, that was that he was using K2 on the date of the offense, correct?
Yes, that's correct.
Judge Edmonds.
Questions on the state's question, Mr. Castaldo?
Yes, Judge. Doctor, the primary basis for you believing that this was substance abuse was the clinical presentation. Is that fair to say?
Well, the clinical presentation in the context of reports of substance use generally, yes.
Well, let me talk about the reports first. The report that the state just mentioned, and the state pointed out that within less than 24 hours of him allegedly making that statement, he's interviewed again and denies ever using K2. Is that correct?
That's correct.
And this was an intake report from RDC, Regional Diagnostics Center.
Yes, it was.
And I'm assuming these intake reports are something that are made kind of on a regular basis.
Yes, typically any time an inmate transfers into a facility, they have an intake assessment.
Particularly for somebody who may have been involved in a high-profile case.
Sure, but typically we do them for everyone.
And the people that do these intake reports typically have a lot of people to manage and gathering information from, correct?
I'm not sure what the caseloads are at various facilities here, so I can't speak to that.
But in your experience in working in corrections in Kentucky, that would not be uncommon.
For them to be seeing a large number of
Yes.
people per day. I'm honestly not sure how many people they see a day. Sometimes facilities can get maybe 50 new intakes per day, but those will be divided amongst multiple clinicians, and they typically have, as far as the mental health clinician, typically have a few days within which the people have to be seen.
And to be frank, you don't know whether or not it was a mental health clinician that did this intake.
I can't recall. I think it might have been a master's level clinician, but I can't recall. I'd have to look at the record to say for sure.
And there are not always mental health clinicians that do these intake evaluations.
Typically, evaluations are done by some sort of clinician or sometimes nursing staff.
But admittedly, he, within 24 hours, when he's asked again, denies ever making that statement.
He denies using K2, yes.
Making that statement and denies using it, correct?
Yes, I don't recall if he said, oh, I never said that, or if it was just more that he denied having used it. But again, I would have to look at the records to say for sure.
It's not uncommon for there to be errors in these records.
Errors can happen, sure, anywhere in healthcare.
So apart from that, in terms of Mr. Dorsey's admissions with regard to the day of the incident, the other information you have is that you did review the interrogation, Mr. Dorsey, correct?
I did.
And during that interrogation, he admits to using marijuana.
He does.
And then he's specifically asked by one of the detectives, Detective, I believe it's Detective Howard, was your marijuana laced with anything? And he says no.
That's correct.
And then he tells Detectives Prater and Howard exactly where in the apartment the marijuana is.
I don't recall that exactly, but he very well may have. He seemed to be pretty open about his use during the interviews with them.
But you don't have any information of any marijuana being collected from that apartment and tested to determine whether or not it was laced.
No, I do not.
And you saw the toxicology reports from Mr. Dorsey.
I did.
And in that toxicology report, Indiana Department of Toxicology tested him, correct? I believe, 16 different classes of drugs. The only thing he tested positive for was THC and THC carboxyl,
That's correct.
which is the active ingredient in marijuana and the metabolite of marijuana.
That's correct.
And when you interviewed him, he did not make any admissions to smoking marijuana wasn't synthetic.
No, he did not.
And in the other reports that you reviewed of other doctors interviewing him, he was specifically questioned about marijuana use, and in all those reports, there was no indication that he admitted to using synthetic laced marijuana.
That's correct.
And you mentioned that it is difficult to test for a synthetic, is that correct?
Yes.
Now, as part of the toxicology report for Officer Leath, which I'm going to, well, let me show you. I'm going to show you what's been marked by identification as Defendant's Exhibit UU, and I ask you to turn to page 4. And actually, look at primarily page 4. Now that's the toxicology report for Officer Leath. That's not done by the Indiana Department of Corrections, but another testing facility. That screening facility does have specific screenings for synthetic marijuana. Is that correct at the top of the page there?
Yes.
And there is also screening for what's termed bath salts,
Yes.
and that would be another term for synthetic marijuana.
That's actually a different kind of synthetic substance.
But based upon that, there was the capability of testing for synthetic marijuana, but it simply wasn't done in this case with regard to any of the marijuana found in the apartment or in blood sample taken from this person.
Not to my knowledge. Again, it's very hard to, it's unusual to see this sort of testing. I've seen it occasionally, but most facilities that I see records from don't routinely test for these kinds of things because it is just so difficult to keep up with any sort of accurate testing.
But again, based upon your information with regards, and we're talking about the day of the incident, because that's the critical time in your evaluation. You'd agree with that, wouldn't you?
Yes.
There is, other than the one alleged admission, which is immediately denied in the RDC records, there is no other statement by Mr. Dorsey, nor any toxicology report that confirms or indicates the presence of synthetics.
Right, there's no lab test to confirm or deny it.
Okay. So let's now talk about the clinical presentation, because I think you said that's another part of what you based your opinion on. Is that correct?
Yes.
I think at this time, we're close enough to 6 o'clock time, and I want to make sure you have adequate time to cross. This would be a good time for us to take a break for the evening. So ladies and gentlemen, before I send the home, lawyers, and talk to you about scheduling. Ladies and gentlemen, I'm going to send you home. But I need to check with lawyers at this point in terms of scheduling. I do believe we will be able to finish everything tomorrow. So, lawyers, come on up. Before I send you home, I'll have to give you the address and also some other housekeeping things to take care of before we do that. So, just stand up and stretch, and we'll be with you in a minute. time because lawyers and I will have to talk about instructions and other things to get those ready for you. But you should be getting argument instructions and begin deliberating tomorrow. Having said that, there are a couple administrative things. For the 3 alternate jurors, I think I told you when you were selected, don't send alternates back with the jury. So the 3 of you will be together in a different space. And so if you all get along together, that's fine. You think you can talk all the time and entertain yourself while the jurors deliberate, that's fine. But if not, I would encourage you to bring a book, bring something that will keep you occupied. I'll have some board games and some other stuff to keep you occupied as well. But you should know that, again, that's an experience where you're separated from them. So you might have long downtime, so you wouldn't want to anticipate that. During the course of the day, at some point, I'm probably going to be feeding you. To the extent that it matters to you, it will be Basbo's Pizza, so if that helps you decide what you're going to eat tonight, that you've been forewarned. I don't know when that will be, whether that will be for lunch or particularly in the evening, if we get to that point. Having said that, I think I've emphasized to you all along that you should dress comfortably. You all have done that. Tomorrow could potentially be a long day. There are no rules for how long it would take you to deliberate. Once the case is given to you, it could go late into the evening as a possibility. So you should dress and bring things to keep you comfortable throughout the day. So again, if you want to bring food or anything else that helps you deal with that experience, that's fine. When you come in tomorrow, we have a slightly different procedure for you. Only in the past year has the state of Indiana increased its pay towards jurors. Because of the increase in pay and the length that you have been here, to the best of my knowledge, you'll be the first jury that I've had who will actually qualify, and you'll have to fill out W-9s for the city, benefit for the tax purposes, so that they will have it on the record so that they can issue that payment to you. I won't have you do it tonight, but tomorrow when you come in, that's probably the first thing we'll give you. You already given it to me? Yeah, okay, fine. Well, then that's why it is, until you've already had that explained to you. And so that's just a requirement. Once you reach a certain level of pay, then you're considered a vendor for city's purposes. So that's just a requirement from the controller. And so we follow their orders, and that's why we give it to you. Again, trying to think if there's anything else administratively to tell you. I think that covers everything. So, again, you're not to form or express any opinion about the guilt or innocence of the defendants. You've heard all of the evidence. The argument of counsel and the court's final instructions. You may discuss this case amongst yourselves, provided that you're all together in the jury room and you don't go to the ultimate question of guilt or innocence. If anyone does try to talk to you about this case, you must remember that immediately. Again, you can talk about the case amongst yourselves, provided you're all together in the room. You don't go to that ultimate question of guilt or innocence. I say it twice, not all. And with that, good night. We'll see you back in 45 minutes.
All rise.
You may be seated. Record should reflect that jurors have left the room. Anything administrative we need to do while Dr. Trivet is still here, otherwise I'll excuse her from being here.
Not from the defense.
Not from the state judge.
Here's the paper. Yeah. Okay, have a good night. In anticipation of tomorrow, I don't expect you to, you don't need to go through the court's instructions, but if you haven't had time to read them yet, please do. They are the stock instructions. I think they're all cut and pasted, so I don't think you have to worry about my awful typing skills. But they should be corrected every once in a while. There's going to be a mistake in there, so if you do see something along those lines, please let Ms. Cochran and I know. Again, reminder, submit your those finals in current new 12-point font. So the record's clear, I think we all agreed that the court will give a preliminary final instruction on the pattern of instructions for insanity, and then let both sides argue the case, and then the court will give its stock final instructions on regular principles. Is that acceptable to the defense?
Yes, Your Honor.
State?
Yes, Judge.
Okay. How much time do you want for final argument? I'm figuring it'll at least an hour, given that you've had multiple week case. Do you think that you need more than an hour?
I don't think defense will be an hour.
I think an hour is sufficient, Judge.
Okay. All right. Think about when, I don't know who's going to do what presentation, but think about what warning you want in terms of midpoint. I will give you a 2-minute warning. If you want a warning before then, towards the end of argument, then you can let me know that as well. But I know you have to split yours, so whether you want it at 30, 35, 40, or whatever, just let me know tomorrow. You guys can think about that. For the defense, it'd be a 2-minute warning unless you want a different time thing. Is there anything else we need to go through administratively?